Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3. This is a test.
I have that problem sometimes. Morning, everyone. We all hope that you had a good Thanksgiving. It's not easy to come in on a Monday right after a holiday, and we all understand that. So we will begin. And our first case of the day is Appeal number 21-1521, USA versus Eric Bard et al.
May it please
Good
the
morning.
court. Oh, good morning, Judge Ropner. May it please the court, Vanessa Eisenman on behalf of Antonio McClure. I'll be arguing Mr. McClure's individual argument as well as the joint argument regarding Detective Hart's testimony. Turning first to the sufficiency of the evidence, this case is on all fours with this court's decisions in Jones and Garcia, and as a result, Mr. McClure's conviction should be reversed.
Can I ask you a question about that? I hate to jump right in, but this, when I read the facts in this case, it sort of looks like a drug deal, it smells like a drug deal, and we're not the jury. It's the trouble that I have with this. He's got these text messages which are really incriminating. Then he shows up, and the officers they watch, they observe, and then they testify to something that looks exactly like a drug deal. Then McClure leaves, and the other defendant is pulled over after he throws drugs out of the car, and the jury says that's enough to convict. I mean, we're not the jury. How do you get over that?
Yeah, I think it's a good question, and I think Jones provides us with an answer. Jones is really, really similar to this case, and in Jones there were a couple of suspicious phone calls. In fact, this was the guy who was, the theory was that he was the cooker, that he was filling in on one day for the cooker who was out. And in Jones there was a couple suspicious phone calls, even referring to a blender and needing to go to Walmart and getting some stuff. And then Jones is in the known drug dealer's car, in his residence, and he's in the car when drugs are thrown from the car. And this court said, in a full decision, that that is not enough because
But this is really different than Jones, because Jones didn't have these detailed text messages. He was captured on the wire, and then in addition to the evidence that Judge Kirsch noted, there's also the jail phone call between your client and Mr. Payne after the fact in coded language that it just adds to what the government put on. And remember, we have to view this in the light most favorable to the government.
That's absolutely right, Your Honor, but we also have to find inferences beyond a reasonable doubt. And here there's absolutely no direct evidence that McClure ever possessed drugs. The text messages that you're referring to, there was one phone call before this meeting took place, and in that phone call there were 4 words: what's the ticket, and 2.
Which the agent testified that what's the ticket refers to the drugs.
Yes, and we have a problem with that too, as you know.
But again, we have to view it in the light most favorable to the government.
Yes,
so
if that evidence was properly admitted.
Let's assume it was.
Okay.
How do you get around that?
Yeah, I think what's the ticket, perhaps, and there was even a special agent that testified later in the trial and said the same thing, that ticket usually by known drug dealers refers to drugs. Fine, ticket and 2. That doesn't mean that he actually possessed drugs, even if he's making an inquiry about it. Where is the evidence that Trice had any drugs in his house on
Was
that
he
day?
charged with a violation of 18 U.S.C. Section 2?
Yes.
Okay.
Yes. That is what we have argued is that's a red herring, because for aiding and abetting, you still have to have knowledge of the drugs. This is not a case where, he's the getaway driver or something like that. You still have to know about the drugs. Again, what did Trice have drugs in his house? We don't know on that day. Did Trice bring drugs from his house to the car? We have no idea. Did Trice give drugs to
Well, you have some
McClure?
idea. It sounds like he went to an apartment building and got the drugs and brought them back.
But where is the evidence that he got the drugs at the apartment?
Well, the
He was
evidence...
throwing out the, I'm sorry.
Right, I was just going to say, I mean, if I was on the jury, I would have said, well, he threw them out of the car.
Yeah, but again, that's what the government was arguing. But where is the evidence that goes inference by inference? This court has said you have to support every inference in that chain along the way. where is the evidence that the drugs that were supposedly thrown out, now Payne's counsel is going to argue about that and has brought it up in his brief, but we assume that there were drugs thrown out of the car. Where is the evidence that those were the drugs that came from Trice? There was nothing exchanged in the car. McClure gets out of the car and no one sees anything on him. Nobody sees him give anything to
But why
Payne.
isn't it a reasonable inference, given there's a wiretap going on, they know Trice is a known drug dealer, they've been surveilling him and up on the wire, your client has a conversation, what's the ticket to, which there's testimony that that's referring to the drugs and the specific amount that's wanted. Then there's the text between your client and Trice saying, on my way, in code, meet you at the A, which we know is this known drug spot, tells him he's here, surveillance and poll cams show that he's there. Trice leaves and returns. McClure gets in the car with Trice and then leaves and it goes in with Payne, and then he gets pulled over later after he's thrown, not he, your client, but Payne, after he's thrown drugs out the window, and then they have this recorded call which the agent testified about. They're using language referring to a drug deal.
Yeah, again, we have to find beyond a reasonable doubt. And this is exactly the situation in Garcia and Jones. This is a couple of suspicious calls combined with mere presence evidence. There was no evidence that McClure had ever dealt drugs. He was never identified in the investigation. He was never known to be an associate of Trice's. So anyone who comes and has a phone call with Trice on that day is going to be guilty of drug possession.
This
That
is a
just
lot more
can't
than a
be-
phone call.
This is a phone call and showing up in his car. That's what it is.
I'm going to ask you why you think that Detective Hart couldn't legitimately opine as to what Mr. McClure meant when he asked Trice, what's the ticket, and what Trice meant when he responded to. Hart said he had heard the term ticket used some 40 times in the intercepted phone calls. So, why would he not offer a lay opinion that ticket meant drugs and Trice's response of two meant $2,000?
Yes. That is not our major problem with Detective Hart's testimony. It's not the ticket in two. Even Special Agent Klein gave expert testimony later in the trial about that. It wasn't our problem, I guess I should say. We argued that it was an improper lay opinion because it was not based on anything that McClure had ever said. But I acknowledge that Trice had used the term ticket. There was much more foundation for the ticket term than for the jail call. The jail call is what we think was entirely improper here. This is two men that Detective Hart had not been investigating, had never investigated. He had never interpreted any of their phone conversations, any of their language, and he says, just because I've listened to a couple of jail calls in the past, I know exactly what these two men who I've never investigated are saying to each other. The government at closing even called this lazy code and inferring or saying to the jury, this is something that everybody should have been able to figure out. Well, yes, that's something the jury should have been able to decide, but to have a lay witness who's the case agent, who was really the entire case against McClure, he testified for 6 hours, and he was the evidence against McClure. To have him go up there and tell the jury, I know exactly what these guys are saying, based on this investigation, which he had not done on those two guys, and to say that I know exactly what they're saying, and they're essentially admitting to the drug deal. That is just a huge stretch.
Suppose, let's say we agree with you that Hart's lay opinion testimony about the meaning of most of the passages that you cited in your brief from that October 22nd phone call were improper. Okay. Why isn't it harmless error here?
Kind of for the reasons that I was just talking about, Judge. It's not harmless error because Detective Hart was the entire case against McClure. Okay, the drugs that were supposedly thrown from Payne's car, McClure was not in the car at the time, and there was not any evidence tying him to those drugs.
But it's a little bit of a stretch to say he was the entire case because they have the wire intercepts, they have the texts from your client's phone, they have the surveillance, They have the poll camera
And
that's
that
capturing.
And that all came in through Detective Hart. And when Detective Hart testifies for 6 hours, and he tells the jury, I just witnessed on the surveillance video that you just saw, we just witnessed a drug transaction. And when he tells the jury, what you just listened to, which everyone had just as much, of an ability to interpret that as he did, when he tells them that's them admitting to the crime, that's all they had. And to have him sorry, did you say something, Judge Ruffin?
No,
Okay,
no.
sorry.
I am watching the clock, though.
Okay, yes. And to have him get up there and say that this was a drug transaction, we all watched it, and to say that this was them admitting, those were inferences that the jury should have been able to make on its own. This was not drug language. He was not an expert. He had not done any investigation against these two before. He should not have been able to tell those things to the jury and essentially tell them that there was an admission. I'm out of time. Thank you.
Okay, thank you. Okay.
Good morning, Your Honors. May it
Good
please the Court.
morning.
My name is Luca Giovini, and I represent the appellant in this matter, Carlo Payne. Your Honors, 2 white jurors with family members convicted of drug charges were admitted to serve as active members on this jury. Alternatively, the first black juror in veneer was peremptorily struck by the government, claiming that the strike was related to the juror's family member convicted of a drug charge. In comparing the...
Was there a white veneer member that was left on the jury whose family member had a drug dealing conviction as opposed to a possession conviction or a generic drug charge?
Your Honor, the answer to that question is that we don't know, and that's because the prosecutor did not actually follow up with jurors 13 and 34 with a single question. If the government was so concerned with family members convicted of drug dealing, hearing the term drug charge should have been a buzzword for the prosecutor to follow up.
Were those jurors later in the jury rotation? I understood the way Judge Sweeney picked the jury, that those jurors were later in the rotation and the government was running out of peremptory strikes. Could you explain that?
Sure, Your Honor. Jurors 13 and 34 were admitted in the first run of jurors. They were part of the first initial 11 active members of the jury. And juror 39, the juror in question that we claim was struck based on race, that juror was in the second round of jurors. And at the time, the government had 1 strike left. And
When you raised your Batson challenge, though, you didn't raise the juror 13 issue with the court, did you?
Your Honor, the defense counsel did not raise the issue with the court. However,
So how can you raise it here for the first time? Why haven't you forfeited that argument?
Your Honors, we're arguing that we did not forfeit that argument. Specifically, the United States Supreme Court in both Miller-El versus Dretke and Snyder versus Louisiana state very clearly that all circumstances concerning racial animosity must be consulted. It's more of a totality of the circumstances analysis, and simply because...
That's true, but I don't think they say they have to be consulted for the first time on appeal.
Your Honor, I'm not aware of any specific language that limits that analysis of...
Certainly the district court should consider all circumstances, that's clear. But the juror 13 circumstance wasn't raised by the defense as a basis for the Batson challenge.
Well, Your Honor, the district court did in fact consider juror 13 and their order on defendant McClure's motion for a new trial. And the importance of juror 13, Your Honors, is that this specific juror claimed that they had a family member convicted of a drug charge. Again, we don't know if that was drug dealing or drug possession. And when you look at the United States Supreme Court's holding in Snyder versus Louisiana, you'll find that the facts of these cases are strikingly similar. Namely, the court in Snyder compared a black juror and a white juror. The black juror had a conflicting obligation, as did the white juror. Nonetheless, the prosecutor decided to strike the black juror and keep the white juror. And in this case, Your Honor, we need to look at those general shared characteristics as required in the analysis by Snyder. The government claims in their brief that the hair splicing argument of drug dealing versus drug charges is the clear rationale that the prosecutor at the time asserted for their race-neutral explanation. However, the prosecutor did not, on the record, admitted that they would have struck Juror 62. Juror 62 was later on in the veneer and did not get an opportunity to serve on the jury. But when the court asked the government whether or not they would have struck that juror, the government conceded that yes, they would have struck that juror. But in fact, Juror 62 had the family member convicted of possession and not drug dealing. So
How do you get around the district court's very specific credibility finding with respect to the prosecutor, which would be the third prong of the Batson challenge?
Your Honor, that is part of the third prong of the challenge. However, that's one factor in a multitude of factors that go into a Batson analysis. I would
You
urge
have
this
to
court.
show it's clearly erroneous. It was a very specific factual determination. And how do you do that?
Your Honor, the court was clearly erroneous in their finding that that jurors 13 and 34 were not as relevant to the analysis as maybe the subjective intent of the prosecutor. I would urge this court to look at the clean record and the objective facts that are stated therein. And Your Honors, I see that I'm out of time, so thank you.
Thank you very much. Okay. Mr. Bald.
Good morning. My name is Jeff Baldwin. I represent Eric Bard. Mr. Bard pled guilty in this case to count 3 and was sentenced to a term of 262 months. During sentencing at the district court level, the government conceded that he was not Mr. Trice or Mr. Stum in the conspiracy. They conceded it's less the conduct and more the criminal history that is driving his guidelines, and that the government further conceded that while I do agree that his conduct did not come anywhere close to Mr. Trice or Mr. Stum, obviously it's his criminal history that's what's driving the guidelines. In this case, Mr. Bard was found to be a career offender based on 2 convictions when he was under the age of 24. At the time of sentencing, he was 35 years old. The one conviction only counted by 4 months as being a conviction that could be used for the career offender based on a violation of probation that he received a 90-day sentence for. That's all that brought it into the time period to consider for a career offender.
You know,
I'm sorry.
When I read through all of this, it seemed to me that Judge Sweeney did expressly consider whether or not the career offender status overrepresented Mr. Bard's criminal history. He had gotten very significant breaks in the past. What is it in particular that you think Judge Sweeney overlooked in this regard?
I believe Judge Sweeney was doing some revisionist history there and he said that Mr. Bard had received such lenient treatment. The first conviction, the one that actually put him into the career offender, the one that was by 4 months, was a Class B felony dealing, which is less than 3 grams of cocaine when he was, I believe, 21 years of age. It was not a lenient sentence for him to get 6-year sentence with 1 year. That was Judge Sweeney's interpretation of what the judge did in state court that decade prior. We also, I think it's important to note that Judge Sweeney based his evaluation of Mr. Bard's criminal history on things that I just, quite honestly, I don't believe he was correct in. For instance, he stated, you had one other conviction where you sold to a confidential informant, but you were only charged or found guilty of possession rather than dealing. Mr. Bard has no convictions for possession of anything other than marijuana. There wasn't a case where he was charged with dealing and pled down to possession. It simply is not in his record. It's not there. He also indicated that you had handguns, even though you were a prohibited person. Yes, he had a 2008 misdemeanor conviction when he was 22 years old for possession of a handgun. That is the only handgun that he has ever been charged with or convicted of. And there was no handguns that were attributed to him in this particular case. So I'm not sure that Judge Sweeney's evaluation of Mr. Bard's record was as accurate as it should have been to base that determination that career offender was appropriate for him.
You're not disputing the guideline calculation, though, are
No,
you? I mean,
I'm
you
not.
agree that he technically qualifies for it.
Technically, and that's the important part. It's the strict, rigid adherence to it when we're talking about a conviction that would have been outside the time limit, but for a later violation of probation for smoking marijuana that brought it into the time period that basically drives Mr. Bard's entire sentence, where he's sentenced to 262 months. Mr. Stum, who also received 262 months, was the leader of the conspiracy, and Jashawn Trice, who was the other leader of the conspiracy, received a sentence of 210 months. If the court has no other questions, I'll be happy to sit down. Thank you.
Thank you very much. Mr. Wood,
Your Honor,
good morning.
counsel,
Yeah.
may it please the court, Bob Wood on behalf of the government. A few responsive points. First, much of Mr. McClure's sufficiency argument is about the danger of a mere presence conviction. Of course, the jury was instructed not to convict on mere presence, and as Your Honor said, the court should respect the jury's finding. The ticket two, I'm going to bounce around because I'm just trying to be responsive and efficient. The ticket two testimony was appropriate for all the reasons the government stated in its brief, but it's also important to note that it's not, strictly speaking, a hard fact that he was testifying to that this means drug deal for sure. He was saying, I was in charge of the wire room that day. I was in charge of sending in the cavalry. And when I heard that, it was my belief that that meant a drug deal was going to happen, so I sent in the cavalry. It was, strictly speaking, fact-based, routine, mine run 701 testimony.
What was the
Let's
foundation?
talk about,
Go ahead, Judge.
Go ahead.
Go ahead.
let's talk about Detective Hart's testimony. When I look at the chart, I can appreciate why it might be appropriate for him, the detective, to explain what jump out boys meant. But when it comes to phrases like something ain't right, or you don't know from a can of paint, I do have difficulty understanding what specifically Hart had learned during the course of the investigation that would give him any particular insight into the meaning of these passages. From the transcript, it appears that the only foundation that was laid for his testimony was his generic knowledge of the investigation, not the prior use of those same terms. For example, by contrast, I do feel that when Hart talked about what Payne meant when he asked Trice, what's the ticket? Hart, the detective, articulated a specific basis in the investigation for knowing what Payne meant by those words. Isn't there somewhat of a problem with a number of these passages?
So, Your Honor, I think, as I tried to convey in the government's brief, there is some distinction in the nature of the foundation between Ticket 2 and the jail call. There's one thing that I'd hasten to point out quickly, and that is that a lot of these passages, there was no objection. And it was not an abuse of discretion, set aside whether the plain error review would apply when there's some objections here and some not. It's not an abuse of discretion for the judge not to jump in. Can of paint, no objection. For the judge not to jump in and say, I object, I sustain my own objection. Or the same would be true for I knew what it was, which is the closest thing to, as interpreted, to an admission, and perhaps one of the most inculpatory pieces. And also, is he 100, in reference to the reliability and trustworthiness of Trice. All of those were not objected to. So fundamentally, was the foundation as firm under the jail call interpretations as for ticket 2? Was it as essentially precipient as the ticket 2 testimony? It was distinct in that regard, and that's the reason the government's harmless error arguments and sufficiency arguments set the jail call aside.
When you say it's not as firm, what was the foundation for the jail call?
The jail call foundation was,
Because he had
in this
not
investigation,
heard these two individuals, either one of them before.
right? And quickly, Rollins, this court has said that there can be precipient opinions about a particular set of individuals, one call, and that foundation was laid here with very, very quickly, I'll acknowledge, but with, have you listened to jail calls throughout this investigation, and are you familiar with the jargon that the people in this investigation have used? The government sees that as sufficient. It's just not of the same type as ticket 2. I see a distinction there. I think our position is that there's a distinction there. But it is important to note that although there was an objection to 2 or 3, I could catalog them with their chart, but I don't have that right in front of me, 2 or 3 of the suspect phrasings and interpretations of those phrasings, there was not an objection to some of it. And when you get down to the harmless error analysis of just this piece, it is not burden shifting to say that they offer no really persuasive alternate interpretations of this testimony. And in that sense, it was not an abuse of discretion for the judge to overrule the objections that were made and to not jump in and object sua sponte where no objections were made. And it's not as though, 2 more things, it's not as though they objected to Agent Hart testifying and interpreting the phone call at all. They let that pass. And it also, under this court, under general Rule 701 jurisprudence and the way this court has treated it in certain cases, I've certainly not seen this, but to play the call in its entirety and just have the jury listen and have no interpretations whatsoever, maybe that is the best course, but it doesn't seem particularly helpful to a lay jury, to me, and that's why the government views it as helpful in a Rule 701 sense. I hope that fully answers your question, Your Honor. In a sense, I agree in that there is a difference, but I don't think that difference merits a different result, both on the merits and for harmless error reasons.
Mr. Wood, before
yeah.
we move off of of Detective Hart's testimony, we laid out in U.S. versus Jett a pretty specific formula for dual agent testimony and suggested a specific jury instruction. And Jett was issued before this trial, and nobody asked for that.
Yeah, the instruction is
happened?
not the same. And the instruction, so I'll
It wasn't
say a couple
even
of
raised with the court in
Right.
advance of the detective's testimony.
Right, and it should have been. It was not.
Well, maybe not.
but-
I mean, defendants have trial strategies too that you can't opine on, right? And sometimes it's better for a defendant, for a judge not to be instructing things like this, particularly if they think the cross-examination is strong.
Right, I agree with that. And in that sense, they signed off on an instruction at pages 350, 351. The parties go through and tailor the instruction. And I have no questions for defense strategy in that regard. What I meant
I was surprised
more
the
was-
government didn't raise
What
it.
I meant was, peeling back the onion a little bit, we've had multiple trainings since Brasher and Jett and Lovey's and all these other cases about how to walk through some of these things. And it's, you're in trial, it's difficult. But the reason for that, to give the prosecutors their due, the reason for that may very well have been, in part, the specific way that the second time the judge gave a contemporaneous instruction, he separated and said on certain matters, he's an expert, and he can testify as an expert on that. And it may be that in the, Warp and Wolf trial, they thought it was unnecessary in that regard. That is an attempt at an explanation. It's not a full attempt at an excuse. I understand completely that Jett said this is what should be used. I think with the court's permission, I'll jump quickly to the Batson issue. The two-wave format, as Judge Kershey pointed out, I think is important here. And in that first wave, using the rubric the defendants would prefer for jurors 51 and 62, the government struck jurors 24 and 26, who were white jurors who said, I have a relative who was convicted of a drug charge. With only one strike remaining in the second wave, the government had to be a bit more discerning, and faced with something like 4 potential jurors who gave answers at that level of generality, gave a more specific explanation. And the result was 2 would-be active white jurors struck by the government for that reason. 1 would-be alternate black juror struck on a more specific version of that same basis. And although it's not core to step 3 of Batson analysis, the racial composition of the jury is relevant to the prima facie case, technically moot, but still relevant.
Were these alternate jurors, by the way?
The jurors, the white jurors who were struck for drug charges, active. The black juror struck, alternate.
You know, I don't know how Judge Sweeney picks his jury, but the rules of criminal procedure are very specific as to how juries are supposed to be selected. You first select the trial jury, then you select the alternates. And it looks like that was not followed here. It looks like, and some judges do this, they lump it all together and they say we're going to pick, first 12 are going to be jurors, and the next 2 or 3 are going to be alternates. That is, you cannot do that under the rules of criminal procedure. And I don't know why judges do that, and I don't know why lawyers let district judges get away with doing it that way. You can't do it, and there's a good reason for it.
Sure, I completely understand that, Your Honor. I will say, to be fair to Judge Sweeney, I have seen judges in our district, in other districts, do that as a matter of course. Maybe they should not do that.
They should
Maybe
not.
This is a lesson for future cases for de novo review of procedural errors, but there was no objection here. It seems to me to be relatively common practice to say, for the judges to say something in effect, so we have our jury and that makes the 2 of you alternates, right? Something like that.
Right, you can't do that. I mean, I've seen district judges too, where they pull names out of the hat at the end of a trial, and as a defense lawyer, I would always object to that and say, Judge, you can't do that. You will be reversed under the rules of criminal procedure. And they would be. The rules of criminal procedure provide for a very specific way
Yeah,
for
and there are
picking
reasons.
criminal juries, and there are reasons for it.
Sure.
You can't just disregard the rules.
At the same time, acknowledging that completely, at the same time, I think this active alternate interplay here is relevant to the Batson analysis.
We've also suggested in our case law that in picking a jury, that the entire veneer should be questioned before strikes are exercised, which wasn't done here.
The two-wave format, which I think owed to some degree to COVID protocols, but it may have been.
Seems like here, at least the way I viewed it, it seemed like there were a certain number of jurors in the courtroom, and then a second
And that
wave
was
of
a
jurors were brought into the courtroom.
Safety precaution. And I've seen Judge Sweeney pick juries before in the room, and I had never seen him do 2 waves before, so that strikes me as something.
I certainly understand the 2 waves, but the exercising of the strikes
Right.
could have waited.
Right. And the exercising of the strikes in 2 waves creates a funny wrinkle for the analysis
Exactly,
here.
right. I think
because
that's part of the challenge here.
all told, you have jurors 24 and 26, and there's just no, in the government's view at least, there's just no problem with 39. But by breaking it apart, he
Right.
essentially created a separate record for a siloed Batson claim by doing that, and also just made the juror comparison analysis a little bit more difficult.
I'm trying to take you somewhere else for a moment, please.
Sure.
Why was Hart not opining on the defendant's guilt when he said that the October 21st video was video of a narcotics transaction? I did not think that the defense counsel invited that comment when the question was simply whether Hart had witnessed the events of October 21st in person.
Well, Your Honor, respectfully, I think that the nature of the question was not at that level of generality. The nature of the question was, you can't say you saw this drug purchase physically in person. And he said, when you put question 1 and question 3 together, it was, you didn't see this drug purchase. What? And then he kind of fought against that a little bit And then the defense counsel said, but I mean, you didn't see it physically in person, it referring to the drug purchase. In the government's view, that's perfectly invited. Also, he was testifying as a fact witness. He had already testified.
I'm sorry, the government what? The government thought that invited it?
The government
what
thinks
you
that invited it to call it a drug purchase. Well, or invited it, or at the very least, you have
Sounds to me
both.
like a yes or no question, does it? No?
It could, but there's sort of an epistemological debate going on there too, in the sense that the defense counsel was testing the quality of his perceptions, watching a video, and he was defending his ability to watch the video and make conclusions on that basis. And in that debate, defense counsel uses this term drug purchase, and he responds with a similar term, sort of in cop speak, narcotics transaction. So the government, in the government's view, that's for the government to have said in direct, is what we're watching here on the video a narcotics transaction? That's not probably a particularly helpful line of questioning, but the way this played out, he was not stepping over any evidentiary lines. It also would certainly be a harmless error for all the other reasons stated. And I don't think I have other follow-ups unless the court has anything. Thank you.
Anyone? No?
No.
All right,
Thank you.
well, thank you. Thank you, Mr. Good. Ms. Eisenman, I'm going to give you your 2 minutes.
Thank you so much, Judge Rovner, I appreciate it. Just a couple of quick responses. Starting where we just left off with Judge Rovner's question, Detective Hart certainly did opine on the defendant's guilt. This is in our appendix, page 22, where you actually physically, you cannot tell these ladies and gentlemen that you actually physically witnessed that in person, correct? And he says, that's inaccurate. They witnessed it now. They watched it on the video. This was a drug transaction. That is opining on the defendant's guilt. That cannot be harmless error, especially when it's coming from the case agent, saying what you just saw, even though you couldn't see any packages exchanging hands, even though you didn't see any drugs, you didn't see any, you don't even know whether there was drugs that Trice had at his house, you just saw a drug transaction. That is definitely not harmless error. Judge St. Eve's question about Jet and the instructions missing, we didn't focus on that quite as much because there wasn't a good objection on that, but I would agree with you. And the main thing that I think here that was confusing was that, there was kind of the standard expert instruction that was given. Okay, we don't really have a problem with how he testified as an expert, but then he goes back into his fact testimony, and there's nothing from the court to say the basis that you have to judge his testimony on as a fact witness is different than as an expert witness. And jury, when this is a witness who is testifying extensively, and he's the case agent, for the jury to know that now I'm supposed to not be evaluating the expertise, but I'm supposed to be evaluating his personal experience and his personal knowledge with the investigation. I think that is extremely confusing.
And the defense didn't ask for it either,
No.
right? At that point,
No.
neither side did,
Yeah.
from my review of the transcript.
Right.
And
So
it
they-
was post-Jet, so I was
Yes.
surprised neither
Yes,
side asked.
I agree. And that's why, we kind of put that all in with all the problems with Detective Hart's testimony and didn't just say, this is a clear violation of Jet, because we did not have an objection there. And then just one other thing about the objections to the other, to the jail call, that's at our appendix 29 through 32. There were multiple objections to this. Basically, defense counsel saying all along, where's the foundation? Where's the foundation for this? And remember, this is not expert testimony, so she doesn't have any prior knowledge that this is what his interpretations are going to be. This is lay testimony. And she says, there's no foundation for this. Where is he getting that? I have no idea where this is coming from. And the court essentially lets it all in because Detective Hart says, well, this is based on this investigation. And that's it. That's all the foundation that there is. But again, he had not been investigating these two men, and there was no evidence that those terms were used by anybody else. in the investigation. So I thank you for your extra time, Judge, very much, and thank you all.
Thank you. All right, Mr. Giovine, you asked for a minute. We'll give you your minute.
Thank you for the extra time, Your Honor.
Oh,
Your Honors, this was brought up multiple times in both at the trial court and on the government's brief. They mentioned this fact that the racial composition of the jury did not change. This is a red herring and is actually exactly against the main principles asserted in Batson. Most every single case after Batson, quote, says, "The Constitution forbids striking even a single prospective juror for a discriminatory purpose." This is recognized in the foundational principle that Batson is not just a right of the defendant, but is also a right of the jury. To argue that the racial composition remained the same and thus there was no discrimination overrides that very firmly established principle in Batson, and Your Honor should not consider that on this review. Thank you.
thank you very much. And Mr. Baldwin, you too asked for a minute, and we'll give you the minute.
Thank you, Judge Rosner, but as the government did not address Mr. Bard, I really have no rebuttal, so unless the court has any other questions,
No,
I
not
won't
for
take your
me.
time.
Okay, is there anything else you want to add before you sit down?
No, thank you, Judge.
All right, well, we thank you. I want to thank each and every one of you, Ms. Eisenman, Mr. Giovine, and Mr. Baldwin. You were all appointed by the court. We thank you for taking your pro bono responsibilities so seriously and doing such a fine job for your clients. And Mr. Wood, as always, we thank the government as well for the fine job that it did today. And case will be taken under advisement. Thank you very, very much. We're going to go on to case number 2. And I will mention this. After case number 2, we're going to take a 10-minute break. So those of you who are in the courtroom have as well, of course. Case number 2 is 21-27-24, United States versus Thomas Alt. And Mr. Rosen, yes?
Yes, Your Honor. Thank you. May it please the court, Mark Rosen appears on behalf of the defendant Thomas Alt. To begin with, as the court is aware, we have 4 issues. To start out, when he first started the interrogation, Mr. Alt clearly invoked his right to have an attorney. When he said unequivocally, "Is there an attorney available for me?" that is a clear sign based upon the relevant case law of this circuit, basically Weisinger and Lee, that is akin to, can I have an attorney? Is there an attorney available? Can I call an attorney? There's no other reason for him to say, is there an attorney available, unless he's saying, give me an attorney. And once he did that,
however favorably to Mr. Alt we might interpret his question about whether a lawyer was available at the site of his interview, he shortly thereafter read aloud the consent form, was told he could stop the questioning at any time if he wanted to consult a lawyer. Why wasn't that enough to confirm that he knew he had a right to counsel, but choosing to proceed without one?
because that was once he invoked his right to counsel by saying, is there a lawyer available? Everything had to have stopped. That's the law. It had to have stopped. They couldn't, that is what clearly the law says. You cannot, they have to just stop and move on and say, okay, you're done. They can't just clarify it They can't just do any of that other sort of thing that they did. They definitely cannot, under the law, do some subterfuge, which the agent did by saying, well, you won't get one, there's not one here until you go to initial appearance. Basically telling, why don't you just talk to us? Because that's what we want to do.
Mr. Rosen, was there a single fact to which your client admitted that was put in trial through his statement alone that was not established with other evidence?
I believe, from my recollection, is that it was basically confirmatory, but I do understand where the court's coming from, but I also understand that the government during closing arguments relied upon heavily upon his statement during closing arguments, and most importantly, as in Weisinger, the jury relied upon his confession. They asked, they were out for a while, they asked, can we hear the confession, the interrogation? They listened for 2 hours. The judge played the interrogation for them, 2 full hours, and then 2 minutes later, they come back with their guilty verdict. And I think as in Weisinger, because Weisinger did say that the jury's reliance upon the confession was clearly a sign that this was not harmless error, because it was, as everybody relied upon it, it was basically done. And it was sort of, to a certain extent, confirmatory. I know the court is aware of the facts of what happened, but that's where we go with it. I think the jury relied upon it. I think the jury materially relied upon it.
The way I understood his defense is that his defense was sort of consistent with his statement. His defense, it wasn't me defense at trial, right?
No, it wasn't.
I mean, so the defense was kind of consistent with, here's what I told the FBI, and that's the truth. I didn't know that this guy was 15.
But still, the jury relied upon it. The jury relied upon him to convict him.
You see what I mean as far as the harmless error analysis?
I see where you're coming from.
If it wasn't me defense, and then you put in this evidence where he admitted, well, it actually was me. That's pretty damning evidence. But here, his defense seemed to be consistent with his statement.
And I can see where the court's coming from, but the thing is, the jury relied upon it to convict him.
How do you know that?
Because I think when you look circumstantially, first of all, the government argued it during its closing arguments. Then you have, as indicated, you have this deliberation. The jury says, we want to hear his interrogation. They listen to it for 2 hours. Then 2 minutes later, they come back with a guilty verdict. So I think that's kind of a whole circumstantial ball of wax to say they materially relied upon it as in Weisinger. I can see where the court's coming from, but I think when you look at that, you can't ignore the timeline of how the jury came to its verdicts in this case. And I know if the court wants to get in, I do have more issues, but whatever the court's willing to do, 15 minutes is...
Let's go into Batson,
Yes.
because juror number 68 did describe a significant negative experience with law enforcement that led him to plead guilty to a charge that his account was a wrongful charge.
That's correct.
Why would that experience not be a legitimate race-neutral reason for exercising?
Because
that?
that's a good point, Your Honor, but because he indicated and asserted unequivocally, first of all, it was a 10-year-old case. It was a DUI. It had nothing to do with a case like this. He did say there was some issue there about that he wasn't the one who did it. But the fact of the matter, he did on multiple times indicate he would not hold this against him. He understood this was a different situation. This was not something he would be able to try this case fairly on its facts and try it on the evidence before him. He would not hold that against him at all. And then the government says, well, we have unconscious bias.
Did the government strike a white juror who was in a similar situation?
I cannot recall that, Your Honor. I do know that this one was the only black juror. My client was black, and this one was struck for this. And as we remember, the challenge for cause was denied.
Yeah, the reason I say that is because here, I think the government struck 2 jurors, 1 white, 1 black, and there was no juror. Usually Batson challenges, as you know, are successful when the juror says, when the government says, we struck the black juror because she's a teacher, and they kept the white juror who was a teacher. That generally creates a Batson challenge. But here, it's very difficult where they say, look, this juror has indicated there are these issues, and we're going to strike him for a peremptory challenge. And the judge finds the government's reason to be credible. And we don't really have anything upon which to reverse the district judge's credibility determination.
Except that I think when you look at the fact that when you look at, first of all, there was no, as far as credibility is concerned, there was no issue of the credibility of Juror 68 with respect to his comments saying, I can try this on the case before me, I will not consider anything that happened in the past, this is a totally different set of facts. He did all that sort of language that all the government's case law they did in their brief didn't have. He really covered himself and he clarified that. And then the government talks about, well, unconscious bias.
But it's fine. But if the government, they just said, we don't believe him. That's what they said. I mean, that's what the government prosecutor said. He said all these things. He could be fair and unbiased. I just don't believe him. And the district judge said, fine, it's no problem. And it puts us in a very difficult position as to determining the government's credibility and overruling the judge on a credibility determination. I mean, I think here the district judge probably would have been fine saying you haven't even met step one.
Except for the fact
we're not there. You don't have to address that because we're not there. He did, and the government provided a race-neutral reason, so that's what we look at.
Right, and I'm just thinking that because of the law says you can't have a pretext for doing this sort of thing. My position is because of the way nobody challenged Juror 68's credibility in terms of his comments. I can be fair.
But aren't they challenging the credibility by exercising a strike and saying he has shown bias against law enforcement? That's
what we're here for,
credibility.
and our position is that it was pretextual. It was designed.
How do you get around the judge's specific credibility finding that they were acting in good faith and it wasn't pretextual?
It's our position it was erroneous, clearly erroneous.
And what do you base that on? What are you asking us to base that on, especially given his answers and the fact, as the government pointed out, that in giving some of these answers, there was hesitation in responding to the judge's questions,
But hesitation means
which is significant.
he's thinking it through and coming up with an answer that he believes is credible.
That's one version of it, but
It certainly is, Your Honor. I cannot discriminate, deal with that. I just think that this, when you look at it in the totality of him coming out saying a 10-year-old DUI conviction, him saying there was a totally different set of facts, that sort of thing, and then they're talking about this unconscious bias. I think that when you look at the totality of it, I think that it basically points, I think it was pretextual, and I think the court clearly erred in making its determination. And I think if we can now get into, if the court's willing, to the third issue, the government instructing the jury on on the definition of beyond a reasonable doubt. I think this is the same sort of situation. The government gave the jury parameters as to what they should do. You cannot not beyond a shadow, but not beyond all doubt. And in Glass, which this court said was basically a defense sort of thing, where the defendant basically argued sort of the other way. It's a bigger burden. The Court of Appeals shot that down. And that's clearly what happened here. And I think when you look at it also under, the government did talk about that. They did give the definition. And then I know that the court basically did a sort of a curative talk. But when you look at the case law, that basically comes out of this case, citing the U.S. Supreme Court, Hall and Berger, Phillips basically said the government, when they get up there and they talk, they have that aura of authority, that aura of impression, this aura of we are the might, the right. And that overcomes, as in the court did in Vargas, any sort of curative instruction. And then you get into this thing where they're talking about, and the whole defense of my client was at trial, was they haven't proven this case beyond a reasonable doubt, that sort of thing.
Mr. Rosen, look, I think we can assume it was unwise for the prosecutor to start talking about what a reasonable doubt is and what a reasonable doubt is not. But it was an isolated remark, as you said just now. The judge reminded the jurors it was up to them to decide what a reasonable doubt was. Prosecutor moved on. I'm having a difficult time imagining the precise harm that was done.
Well, I think when you look at the case law saying, when the defense does it the other way around and sort of hedges and says, well, it's this, it's, bigger than this, then all of a sudden that gets shut down and all of a sudden it gets lectured at. And also given the fact that this court has done in Phillips and Vargas, said that when the government says a definition, it carries a lot more weight because of their authority, their imprimatur, that sort of thing.
But the court quickly issued the curative instruction saying, I haven't instructed you on beyond a reasonable doubt. It's up to you to determine that.
And I
Why
understand.
didn't that cure any potential problem from the government's statements?
Because Vargas is right on point on that. When the government does it, it's not enough because the government has that authority of, we're the government, we are the government, and that's what the Vargas court said. I can't remember the exact language that was in that case.
That was a 1978 case. We have since said that instructions from the court carry more weight with jurors than do arguments made by attorneys.
And I understand, but there's still court case law that says that the government, when they do talk, that carries a good deal of, because of the authority of the government. I see, with all due respect, I have 2 minutes left, if I may be allowed to reserve that for rebuttal.
Of course.
Thank you, Your Honor.
Thank you. Ms. Boyle?
Good morning, Your Honors. May it please the Court, Counsel, my name is Catherine Boyle on behalf of the United States. Your Honor, I'd like to turn immediately to the suppression issue that opposing counsel raised first. The district court here correctly denied Mr. Alt's motion to suppress statements because he did not unambiguously invoke his Fifth Amendment right to counsel. At the outset of the interview, he asked, should I have a lawyer? That's not an invocation. That's very clear based on this court's case law. And then afterwards, the agent spends a significant amount of time. I'm sorry, Your Honor, did you say something? Thank you. Afterwards, the agent spends a significant amount of time making sure that Mr. Alt understands English, going through his advice of rights, and
You know what, Ms. Boyle, you know what concerns me about this particular case? I'm with you on that, okay? I mean, I don't think he asked for a lawyer, I'll start with that, but the thing here is the agents, this interview I think took place at the FBI building, and usually we see these types of situations, usually, when the agents are seeking some form of cooperation from the defendant as to others, not generally when they're just seeking evidence to shore up what is overwhelming evidence of the defendant's guilt. And sometimes the agents create their own problems, like this one here, where Mr. Alt is probably going to be convicted beyond any doubt without his statement, right? And I mean, the government didn't even really need to use his statement because, as I indicated, I think his statement was consistent with the defendant's defense. I told the FBI the truth. I didn't know he was 15, and that's what I told the FBI, and that's what I told. The jury, or everything is the same. But it sort of creates problems in these situations where the FBI does not interpret, particularly a second statement. The first one is just a question. The second one is, do you have a lawyer here? Is the second time he raises the lawyer issue. And of course, they don't have one there, and the FBI agent properly tells him you're going to be assigned one or you'll be appointed one at the initial appearance. But that statement indicates to me that maybe the FBI agent even interpreted it as him asking for a lawyer. And it's this, does that make sense what I'm saying? It's a dangerous situation to be in, because if it was a real close case, and if he had said it a little bit differently, or it wasn't recorded, then you have even maybe a problem that is of sort of the agency's own creation.
Well, Your Honor, first of all, I agree, and I think that this was noted during my opposing counsel's argument, that in this case, the information from Mr. Alt's interview was largely confirmatory of other evidence, as my co-counsel has admitted. In these cases, we frequently do see law enforcement agents attempting to conduct interviews. And, I was not the district court prosecutor on this case, but I think one of the reasons is whenever there's devices, you see people saying, it wasn't mine, it was my roommate's, all these various things. And certainly the government believes the evidence was very strong in this case, so whether that defense would have been successful at trial is perhaps it wouldn't have been, but that doesn't mean that they don't want to question the defendant and get out in front of it. And the other thing is we do sometimes see cooperation in these types of sting cases and Project Safe Childhood, which are cases involving child pornography and all of that, because sometimes we end up having people agree to let law enforcement use their devices, which allows them to investigate potential other crimes. So I think there are reasons to conduct these interviews. To answer some of
And I think there are too. I just didn't see it in this case. This case, it looked to me like the interview was just, let's confirm your guilt. And that's it. We're going to get a gotcha, let's confirm your guilt. And he comes pretty close to asking for counsel. He comes pretty close. I mean, in my view, at least, he doesn't get there all the way. But at least the agent kind of believes that too when the agent says you'll be appointed one at the initial appearance. In other words, you're not going to get one now today here in the FBI building, but you'll get one when you go to court.
Well, I think if you look at exactly what the agent said when he was reading the advice of rights and sort of what Mr. Alt was responding to, he says, if you can't afford a lawyer, one will be appointed for you before any questioning if you wish. If you decide to answer questions now without a lawyer present, you have the right to stop answering at any time. Mr. Alt says, yep, and then the attorney, the FBI agent continues explaining, so no matter what you say, if you decide that you want to have a lawyer, then we stop, so just any time. And when you look at what Mr. Alt says in response to that, it's very clear he is just asking a question about the process, and that question about the process is meant to inform him whether he's going to go ahead and talk right now, which is his choice. He may be doing this because he thinks this is, I can talk myself out of trouble and I want to do it immediately.
The agent's response did not seem to be the most responsive to his question at that point, because the agent had just told him, if you can't afford a lawyer, one will be appointed for you before any questioning if you wish. And then he goes on, Mr. Alt asks about the appointed lawyer, do you have a lawyer here? And his response is ultimately, so that would be appointed at your initial appearance.
Well, and I think that is specifically with...
As opposed to right now, which is what he was talking about before.
Yes, I think Mr. Alt's question, Mr. Alt seemed most interested in a lawyer who would be appointed rather than retained counsel, and it is likely that appointed, I think the agent was just trying to be as truthful as he could be. If you are going to be appointed counsel, that generally would happen at your initial appearance. I also think if we look at exactly what Mr. Alt said, it's important. He says, and real quick on the appointed lawyer, do you have a lawyer here? Real quick suggests to me that Mr. Alt was not intending to halt the interview. He was just trying to decide, he may have already decided to proceed with it. He might have said, if you had a lawyer here, please bring them over. If you don't, okay, I'm going ahead anyways. So I think when we look, this is really a process-based question, and the agent tries to give him a process-based answer, which is if you are looking for an appointed attorney, that is somebody that you would see at your initial appearance. And it seemed, I really believe that the agent here was just trying to explain the process to Mr. Alt, and Mr. Alt seems satisfied with that answer and goes on. This is very similar in some ways to Lord versus Duckworth, where the individual says, I can't afford a lawyer, but is there any way I can get one? They're trying to figure out, how and when they might have an attorney, and in that case, if they want to proceed answering the agent's questions, or if they would instead, prefer to wait until counsel was there. As this court has talked a lot about action-oriented language, and I think it's also important to note Mr. Alt's question is not action-oriented here. It's really seeking information. And certainly, even if this court believes that there is more than one interpretation of what Mr. Alt said, this court has held previously that alone shows that this was an ambiguous statement, if you can make an argument for either interpretation. So here, Mr. Alt just made a choice to begin speaking right away rather than to wait for appointed counsel. Our alternative argument, of course, is that any error was harmless, given the overwhelming evidence against Mr. Alt. My opposing counsel has agreed that the interview information was essentially confirmatory of what was already in evidence, and that's particularly true here, where you have we're not even particularly worried about identity, which sometimes is one of the issues in these cases, because you have Mr. Alt sending a picture of himself, and then that's the same person who shows up at the meet site after sending these explicit text messages with marijuana, a tablet, and an iPhone containing the Grindr application. So really here, the information from the interview did not provide anything additional that was needed to convict Mr. Alt in this case. There was already sufficient evidence to sustain the conviction. My co-counsel...
Why didn't you go on to the Batson issue?
Yes, Your Honor.
Because it seems to me, black individuals do have disproportionate rate of negative experiences with law enforcement. If we allow that as a routine basis for striking such jurors, aren't we increasing the odds that a jury will not be representative of a defendant's community?
Your Honor, I think that's a real concern. This court has discussed that issue in United States versus Brown, I think a 2016 case, and has said, however, that disparate impact, what you need for Batson is you need purposeful discrimination from the government, which is not something that occurred here. We are, of course, always concerned about disparate impact as well, but we're not even talking about, in this case, an individual who has potentially had certain negative experiences. This isn't with just law enforcement officers. This is an individual who also said that he had a negative experience essentially with the entire justice system, and to the degree that he said he pled guilty to something he didn't do. And I understand defense counsel said that this was 10 years ago, but this is something that was still so sensitive. The juror didn't even finish filling out the questionnaire on that point. And as the prosecutor noted and the district court observed, expressed hesitation and shrugged when they were discussing whether they would be able to be fair. And this is a case where the government had 4 law enforcement witnesses, and it was important to the government to believe that it could get a fair shake. The district court clearly didn't err in finding that the government had produced a race-neutral reason, and this court has previously suggested that a bias against law enforcement does qualify as such a reason and has declined to overrule the district court, especially under the standard where the reason proffered has to be outlandish, or you would want to see some other evidence that the government was engaging in purposeful discrimination. There's no reason for the court to decide that the government had intended to purposely discriminate. They didn't. If Your Honor,
Do you want to go on to the reasonable doubt remark?
Yes, Your Honor. So
would it have been more prudent, do you think, for the court to have sustained the objection to the remark about reasonable doubt, instructed the jury to disregard it at the time?
Your Honor, I believe it would have been the more cautious approach for the government not to say anything on reasonable doubt in this case. I do think, however, even if one were to view the remark as improper, it was very brief. It was just an isolated comment. It didn't really get to what reasonable doubt was. It just briefly said, it's not this. The prosecutor immediately stopped speaking about it after the objection. The district court judge didn't sustain the objection, but clearly instructed the jury, the meaning of reasonable doubt is up to you. So any potential prejudice from this very mild, brief comment from the prosecutor, especially given the fact, as Judge Saini mentioned, that the jury gives more weight to what a trial court judge says, I just don't think that it presented a problem. And I think especially when we look at the remaining circumstances in this case, we have the trial court's instructions carrying any potential prejudice, the written instructions, the oral instructions all emphasize the burden without defining it. The court emphasizes that the burden is up to you. The defense mentioned during their closing, it's up to you to define reasonable doubt. The prosecutor in rebuttal said reasonable doubt is the standard, made no attempt to define it. And we also, as we've discussed earlier in the context of the suppression motion, the evidence in this case was really overwhelming against the defendant. This is not a situation where a brief isolated comment on the part of the prosecutor made any difference to the outcome of this case. If your honors have no further questions on any of these issues or the supervised release issue, the government would ask that the court affirm and rest on the arguments in our brief.
Thank you very much, Ms. Boyle.
Thank you, your honors.
Mr. Rosen asked for 4 minutes. He has 2 left. Give him the floor, please.
Thank you, Your Honor. Thank you, Judge Rovner. I don't believe I will need the 4, but I appreciate the offer. I think when you talk about, and I know where the judge is coming from, when you say, do you have a lawyer here? He said that, my client said that immediately asked after being Mirandized. And I think that is clearly where he's coming in, where they talk about you have a right to an attorney, you have a right to remain silent, you have a right to have an attorney before questioning. It all falls into that same package where you're talking about getting an attorney. And I think he asked, and I think based upon this, government cited Lord versus Duckworth. I think Lord versus Duckworth did talk about this sort of language because Weisinger cited it, and Lee talked about the Lord versus Duckworth language as can I have a lawyer? That sort of language is basically saying I want a lawyer, and that is unequivocal under that case law. And I know where the court is coming from about this sort of issue about harmless error, but once again, we're talking about the way the jury interpreted it and the way the jury utilized the interrogation and what the jury did to do it. And the jury, I think in this case, clearly found it to be dispositive in terms of finding my client guilty, I think based upon the timeline that I talked about during my argument. I think the government talks about, well, he would have talked anyway. I think that's all speculative. We don't know what he would have done. We don't know what he would have done. All I know is that immediately after being Mirandized, my client said, do you have a lawyer here? And then the agent started, well, no, we don't. You won't get one till later. Basically just shoving all that away and basically having my client talk. So anything about that he would have talked anyway, they think is speculative. As far as the Batson issue is concerned, I think as far as the bias is concerned, the words of Mr. Jane, the juror 68, contradict bias. I think that when you're looking at it, the bias that juror 68, that the government says might had against law enforcement was, as the government itself said during trial, was unconscious bias, because juror 68 clearly said, it's a totally different matter. I can decide this case on its own. And basically, these are separate facts. This is 10 years old. It's a DUI. It's got nothing to do with the sort of case. And basically, that's what happened about this. And the government's cases, they cited James and Hendricks and things like that, never had that language by the juror where he basically clarified, saying, I can do this and I can judge this on my own. The government says that the government during closing arguments did not provide a definition of beyond a reasonable doubt. The government provided parameters of beyond a reasonable doubt. And I know that Judge St. Eve talked about how a curative instruction now kind of solves that situation, but there's still the issue that the government has the imprimatur, the authority, the sort of appearance of that they know more than everybody else in it, because they are the government. We are the government. And I think that law has not been changed, and I think that that still should be recognized. Basically, Glass, the defense started talking about parameters, and that got shut down. The same thing happened here. The government provided parameters, and it should have been shut down. And I think, based upon individual reasons and cumulative for all the reasons, I think my client is entitled to the relief we seek, Your Honor, which is a new trial. Thank you very much.
Mr. Rosen, where are you?
I'm sorry.
Everyone runs away. You don't have to be sorry.
I apologize.
No, Mr. Rosen, thank you so much. You too, you were appointed by the court, and you certainly have given your all.
Thank you.
And we just appreciate it so much. Thank you. And Ms. Boyle, As always, we thank the government, but particularly today because of the very forthright way in which you responded to the questions. Thank you both for your service. It is really appreciated. Case will be taken under advisement. We will take a 10-minute break. Thank you. Okay. Good morning. Third case of the day. Appeal number 21-1730, Benjamin Adams versus Robert Collier. Hello, Mr. Millman.
Good morning, Your Honor. May it please the court. My name is Jack Millman, and I represent the plaintiff appellant in this case, Benjamin Adams. This is a very complicated case with a lot of facts, but what is not complicated is that the district court erred in granting summary judgment to the defendants because it did not view the evidence in the light most favorable to Mr. Adams. In particular, it did not credit Mr. Adams' deposition testimony.
Mr. Millman, can I ask you a question about that, about the evidence? On the First Amendment retaliation claim, what is the evidence? I think it was Feldkamp who did the investigation.
That it was Feldkamp who did the investigation.
Yeah, he was the, I just forget all the names. Feldkamp was the officer who did the investigation.
Yes, Your Honor.
Your client filed an ombudsman complaint against Feldman,
Yes.
and then Feldman conducted the investigation. What evidence is there specifically that, beyond speculation here, what evidence is there from which a jury could find a causal link between the activity and the retaliation, meaning between the ombudsman report and the retaliation, the investigation?
I think a reasonable jury, viewing evidence in the light most favorable.
What
to
evidence
Mr. Adams
specifically?
would be the fact that the report was false and that Officer Feldkamp knew it was false, that there are specific portions of that testimony or of the report that if Mr. Adams' testimony is credited, particularly about the PayPal transactions, the video surveillance, the prior incidents with the injured inmate, that Mr. Adams said, look, the video evidence will show that I did not take commissary from him. If all of that is credited by a jury, the report into the February 5th incident would have portions which blame Mr. Adams, which must be false, combined with Mr. Adams' testimony and other evidence that he was not involved at all in the February 5th assault. So
Yeah, but that's a problem for you because the injured inmate implicated Adams in the attack. Right? So the injured inmate says it was Adams was involved, Adams was the one that ordered the attack.
that was
And there's no evidence that that inmate lied to Feldman, or Feldkamp. I keep saying Feldman, Feldkamp.
So Feldkamp's report stated that's what the injured inmate said, but that would conflict directly with other, for example, inmate Garrettson, who said that Adams had no involvement. Adams himself.
But that doesn't contradict what the injured inmate told Feldkamp.
Yes, but in the report, it also talks about the PayPal transactions, which Adams' testimony said, look, if you look at those transactions, they would not implicate me at all. So that does directly contradict what's in the report.
But did Mr. Barnett or Mr. Mr. Garrettson ever say that they told Feldkamp Mr. Adams was not involved in the assault? I mean, Garrettson's affidavit doesn't say that.
So Garrettson sent an email to the ombudsman saying Adams wasn't involved in the assault, and he also had a sworn affidavit that says Adams wasn't involved in the assault, which Adams presented as evidence to try to say he wasn't involved
No,
in the assault.
I know all of that, but what I'm saying is, did they ever say that they told Feldkamp?
So I believe that Feldkamp, as part of his investigation, did talk to offender Garrettson. Whether Feldkamp specifically saw the sworn affidavit, I mean, at some point it came in, likely at the first hearing with DHO Peltier in March. But I think a jury could reasonably infer that Feldkamp was aware of this, at least by the second hearing, if not the first. But as part of his investigation, presumably saw Garrettson sent that email to the ombudsman saying that Adams wasn't involved in mid-February. So that was while the investigation was ongoing.
But if it's not until the second hearing, how can the action be retaliation?
So
If
that's
you
just
can't
one.
establish it by the initial hearing and the initial proceedings, how would it be retaliation?
So the evidence for retaliation, as for the first hearing, in particular is that the report contained knowingly false information, such as the video surveillance, the PayPal transactions, and the history of Adams allegedly taking commissary from the injured inmate. All things that could have been, Adams could have been cleared had they looked at the primary evidence.
And what raises the issue of fact, back to Judge Kirsch's question, that Feldkamp knew that report was false? I know you're saying, here's this other evidence that raises an issue of fact whether or not the report about the assault itself was false. So assume there's an issue of fact there. What it raises the issue of fact as to whether Feldkamp knew that was actually false when he filed it?
The contents of the video surveillance, the PayPal transactions, and the other alleged evidence that Adams took the commissary or was directly involved in the commissary. These are three things where Adams credibly testifies, look, these primary sources clear me. And there's no explanation for why the report would contain this false information if Adams' testimony is credited, which it plausibly should be credited.
Is there any evidence that any of the defendants other than Feldkamp knew of the omnibus complaint being filed?
There's no direct evidence that I'm aware of in the record, Your Honor. I think a reasonable jury could take a look at all the circumstances of how this unfolded and see that if, Feldkamp wanted to get Adams, he did not like Adams. I think the record is pretty clear on that.
But it has to be retaliation for First Amendment activity. So even if they knew Feldkamp didn't like Adams, you have to link it to the First Amendment activity, which is the filing of the complaint here.
Yes, Your Honor. I think you could look at it as they facilitated Feldkamp's retaliation. They sort of conspired together to hold this sham hearing and then kind of...
I don't think a conspiracy was charged.
A conspiracy...
It was a First Amendment retaliation.
A conspiracy count was not pled, but he did, in his operative complaint, talk about how they conspired together to deprive him of his First Amendment rights.
What evidence is there that Feldkamp knew of the ombudsman report?
So there's no direct evidence.
What circumstantial evidence is there?
So there's 2 points, Your Honor. One is I believe that on the direct evidence point, this is forfeited. There's been multiple times where defendants could have said Feldkamp did not
Forfeited by the state.
defendants.
But can't we affirm on any basis? What's the problem with that?
So the
I
problem...
mean, if there's no evidence, there's no evidence. We can't send it back to trial and tell the district judge, good luck with this trial. There's no evidence whatsoever, but you have to try it anyway.
So one thing is that this is a very easy question to answer. You just ask Feldkamp, did you know? And I think it's telling that they've
Did you
avoided-
ask him? I mean, you didn't represent him below, but did anybody ask him?
So it was litigated pro se below, and from what I can tell, it appears everyone sort of assumed he knew. And so in the defendant's motion for summary judgment, they don't discuss this at all. This factual issue is not developed. And Seventh Circuit case law is pretty clear that if a factual issue is not developed at all in summary judgment, it's forfeited. The defendants can't rely on it now on appeal when it was never raised below. And I think in particular this case, the court need not reach the forfeited issue because it's so easy to answer the question. One simply has to ask a single interrogatory, a single question at trial, did you know? And the fact that they've avoided answering that question for the 3 or 4 years that this proceeding has occurred is to me telling that Feldkamp knew of the ombudsman.
Well, it sounds like they didn't avoid it. They were just never asked.
They put in for their summary judgment motion a declaration by Feldkamp that walks through various points, and it never says, I was not aware of the ombudsman report.
They didn't dispute it below, did they?
They did not dispute it below.
Go ahead, you can continue.
There's 3 other issues besides First Amendment retaliation here. Given the time, if your honors would like to talk about another one of the issues, the Eighth Amendment due process, or the equal protection.
Yeah, is it your position that Feldkamp or any of the other defendants can be liable for the conditions that Mr. Adams experienced in segregation simply because they helped send him there, even if they had no control over the conditions themselves?
Yes, Your Honor. So there is another case below, a district court decided, Vermillion. I know it's a district court, but it was applying Seventh Circuit precedent, particularly Knight, that talks about how a defendant can be liable for an Eighth Amendment violation if they control the conditions or facilitate, turn a blind eye to the conditions. And in that Vermillion case, similar to here, it involved defendants who basically filed a false report, got the inmate sent to horrific conditions, and then could have done something to get the inmate out of it by telling the truth, but instead continued to play games to keep the inmate in the terrible conditions. And here, the evidence is pretty clear that they knew of the bad conditions. He filed an amended complaint, and the defendants don't dispute that the conditions were terrible. So the only question is whether any of the defendants had sufficient facilitation or control to be liable. And again, summary judgment, so viewing the evidence in the light most favorable to Mr. Adams. I think that it's certainly true for Commissioner Carter because he had overall control, and Feldkamp.
How did Feldkamp have control over the conditions of confinement?
So he facilitated the Eighth Amendment violation, both by creating a false report.
But the law is pretty clear on the Eighth Amendment under 1983 that you have to have control over the conditions in order to be liable under the Eighth Amendment. And I don't see any evidence of Feldkamp having control over those conditions.
So, Your Honor, I think with Knight v. Wiseman, which is a Seventh Circuit case, and they talk about when a defendant would be liable for a constitutional violation, it is not just control. I mean, control is the clearest path, but I think in a case where they facilitate, sort of deliberately indifferent, they know the conditions, they facilitate the person's suffering, and then they have control in the sense that they could stop it by doing the right thing, but they don't. That is also enough under the case law. And that was similar to the issue in the Vermillion District Court case, where the defendant officers did not directly control the violation, but they still facilitated it through the false report. If you honest have no further questions, I'll reserve my 3 minutes.
Good morning, and may it please the court. The state asks that this court affirm the district court's grant of summary judgment because no reasonable jury could find for Benjamin Adams on his 4 constitutional claims. Adams failed to designate any evidence to contradict the state's evidence that the defendants did not violate his constitutional rights.
I want to take you right into the due process claim because I have a threshold question about that. You want to separate the decision to sanction Mr. Adams for the assault case from the subsequent decision to reclassify him to department-wide restrictive housing. I understand that the reclassification decision was a separate decision based on the fact that he had racked up 8 disciplinary violations in 1 year. But I gather that the assault violation was one of those 8. And Judge Hanlon thought there was at least a question of fact as to whether the assault finding contributed to the decision to reclassify him. So would you please address that point?
Yes, Your Honor. Actually, the state thinks that this court can address the due process grounds, the due process issue by looking at the merits and considering whether he received due process in the disciplinary proceedings. I understand the classification, the department-wide restrictive housing and the disciplinary segregation issue is confusing, so we think that the court can go ahead and look at whether he received sufficient due process in the disciplinary proceedings. So if I could explain that. The only loss here, the only harm that that Adams suffered was his placement in segregation or restricted housing. And because of that, this court should look at whether he received the informal due process protections.
Do you agree that a neutral reviewer is part of the informal placement protections?
Yes, Your Honor, we do.
Well, you know, one of his theories, of course, is based on his assertion that he was deprived of a neutral reviewer. And if we put together what Officer Peltier allegedly said to Adams about Feldkamp making sure he's going to segregation for a long time, and it was out of Pelletier's hands, with what was it, Gagnon told him about hearing officers being given instructions about what to find and what punishment to impose. Wouldn't all of that support an inference that the hearing officers were simply doing Feldkamp's bidding here?
No, it doesn't, Your Honor. First, Officer Gagnon's statement is inadmissible hearsay. That comes from, it's either from Adams' declaration or his deposition testimony, and Gagnon is not a party in this case. Also, what Officer Peltier said about higher-ups directing him to find Adams guilty was in the cell phone case and not in the conspiracy case. And Your Honor, what was the third? I apologize. The third question.
Well, Peltier
Right, Your
said
Honor.
it. Okay.
Yes. So Peltier did say, according to Adams, that Feldkamp wanted Adams to go away to segregation for a long time. But I don't think that this supports that he was denied an impartial decision maker. In the conduct report, Feldkamp's cites says that there are.
How about, let me just add on so you can respond to it. He didn't just say, according to Adams, that Feldkamp was going to make sure he went away for a long time. He also said it was out of his hands.
Your Honor, I think that was in the cell phone case, if I'm not mistaken, that where Adams is talking about Peltier saying it was out of his hands. But in regard to Feldkamp allegedly saying that he wanted Adams to go away for a long time, in his conduct report, he said there were aggravating circumstances in this case. So Feldkamp believed that Adams conspired to injure this offender and that him and Barnett and Garrettson should receive segregation for it for a long time. So I don't believe that supports that Peltier wasn't an impartial decision maker. Also, I wanted to briefly point out that in his response to our motion for summary judgment, Adams' complaints in regard to due process were primarily that he was denied witnesses and evidence, and not that he was denied an impartial decision maker.
That was one of his arguments, though.
Right.
I'm sorry, in what? Your
That he
Honor?
was denied an impartial decision maker.
That was one of his arguments on appeal, yes, but in his motion for summary judgment and in his many declarations he filed in opposition to the state's motion, he focuses mainly on being denied evidence, being denied witnesses.
He did complain about the reviewers, if I recall. I mean, it's pro se, so we have to construe it liberally. He did seem to complain about the reviewers.
He complains about them mostly in the terms of the retaliation and equal protection, but he didn't designate any evidence to support those claims.
I think given that it's pro se, that might be a stretch to say that. If we review it liberally, as we have to, I think there's sufficient information that he complained about his reviewers below.
And even if the court does, I don't think there's any evidence that he was denied an impartial decision maker in this case.
What about Feldkamp's email to Andrews, when Andrews forwarded the emails from the disciplinary review officer?
Your Honor, the email was sent actually after the disciplinary hearing, so that doesn't show that Andrews wasn't impartial in the disciplinary proceedings. But also, a lot of times we ask.
Can I ask you one question real quick?
Yes, Your Honor.
That email that you're referring to was after Andrews ruled in the disciplinary proceeding, right?
Yes, I think it was in November, and the disciplinary proceedings.
Yeah, it was in October 2017, so
October.
the email came afterward.
Yes, Your Honor. And also, a lot of times we ask investigators about why evidence was denied, whether it was supposed to be kept confidential. So he could have just been referring to that. But I don't think that email alone supports that Andrews wasn't impartial. And then if there are no more questions about the due process, I'd like to move on to.
No, I want to talk to you about the way the government here has read Westifer versus Neal for the broad proposition that any decision as placing an inmate in segregation requires only the most informal procedure and never requires that an inmate be given the benefit of live witness testimony, for example, because it seems to me that our more recent decision, I guess, in Williams, although it's not precedential, suggests that when we're talking about disciplinary segregation, more may sometimes be required. Here, we are given some reason to believe that Barnett and Garretson would have exculpated Adams. Why wasn't the hearing officer required to hear their testimony before deciding who to believe?
Well, Your Honor, the reason that we believe that only informal process is required is because if you look at the Supreme Court's precedent, specifically in Wolf, they recognize that different liberty interests require different types of process or protections. And the court in Wolf recognized that the loss of earned credit time didn't require as many protections as parole revocations. And so if you look at Wilkinson and Hewitt, they talk about those, that the liberty interest involved in placement in restrictive housing doesn't require as many protections as when an offender is losing earned credit time or being demoted in credit class. And so it makes sense that informal due process would apply in this case, even though the avenue or the mechanism that got him there was a disciplinary hearing. I'd like to move on to the retaliation claim. Adams didn't designate any evidence that would contradict Feldkamp's testimony that he genuinely believed what he put in his report was true, that he believed the injured offender, that Adams conspired with Garrett and Barnett to assault him and to take his commissary. Adams relies on the Gale case from the Second Circuit to say that Adams' own testimony and his many declarations that he didn't commit the assault is enough to create a material issue of fact. But it's not, because it's not whether Adams actually committed the assault, it's whether Feldkamp believed Adams committed the assault, or whether he believed the injured offender. And there's no evidence here that Feldkamp did not genuinely believe that Adams committed the assault. Does anyone have any questions on retaliation before I move on? I'd briefly like to touch upon opposing counsel's argument about the Eighth Amendment claim. There's no evidence that any of the named defendants had any control over Adams' conditions of confinement. And this is especially true given that Adams was in restrictive housing at Wabash Valley for a lot of the time, and none of these defendants actually worked at Wabash Valley. Also, in Adams' own deposition, he admits that they had no control over the conditions of confinement. And as to Commissioner Carter, the the state argued in its brief that Commissioner Carter, the Eighth Amendment claim wasn't actually against Commissioner Carter. But I think even if you look at the, even if you think that it was, the complaint was only on Carter's failure to train his officers. And a failure to train is an official capacity claim, and opposing counsel admitted in his reply brief that the injunctive relief here is moot, and so Adams cannot obtain any relief from Commissioner Carter. And then finally, there's no evidence that any of the defendants violated Adams' equal protection rights. Adams failed to show that he was similarly situated to either the injured offender or offender Garrettson. He was not similarly situated to the injured offender because Feldkamp and the other officers believed he was the victim in this case, and so he wasn't charged. He was also not treated differently from offender Garrettson. Feldkamp charged Adams, Garrettson, and Barnett with the A100 offense, and he recommended I'm sorry, Your Honor. Adams didn't show that Feldkamp charged him with the lesser offense, and Adams didn't produce any evidence to show that any of the other defendants treated Garrettson differently.
What about the punishment? I thought one was 1 year and Adams got 2.
Yes, Your Honor. Barnett and Garrettson both received 1 year. Adams got 2, but the second year was for another offense. So they all only received the 1 year for this offense, and that's supported by the conduct report. And also there's an email, I believe, that lists all 3 offenders and the sanctions that they received. And there's also no evidence that Feldkamp was motivated by the filing of the. Oh, I'm sorry. There's no evidence that a reasonable jury could conclude that. I lost my. There's no evidence that Feldkamp intentionally discriminated against Adams based on his race. Adams relies mainly on one statement, but that was a statement that Feldkamp used in the course of his investigation to get information regarding an officer and whether she was improperly mistreating other offenders. And there's no evidence that Peltier, Andrews, or Penfold were motivated by race. So because Adams didn't produce any evidence that contradicts the state's evidence that shows that the defendants did not violate Adams' constitutional rights, the state asks that this court affirm. Thank you.
Thank you very much. Mr. Millman, come on up. Would you change that to the full 3 minutes that Mr. Millman had requested, please? Thank you.
Thank you, Your Honor. Just a couple quick points. First, the deposition transcript was designated as evidence in its entirety.
But Mr. Millman, here's the problem that I have with the causal link. We have this ombudsman complaint that was filed, and then we have your client's testimony that Feldkamp's report was false. You nitpick little things in the report, the PayPal and the video surveillance and things like his report was false. But what evidence did Adams designate that could be used as a causal link to establish that Feldman didn't believe that his report was correct? And I think the state hits the issue and describes the issue correctly, because the report can be inaccurate. That's okay. Adams can't nitpick the report and say, well, here's this little falsity, and from that we can infer retaliation and I'm entitled to a trial. That would turn our retaliation law on its head. I mean, what evidence was designated that Feldkamp knew that the report was false?
So I would go back to the primary sources that Adams says would directly contradict what was in the report, which would be both the video.
I got that, but that doesn't say, that has nothing to do with Feldkamp believing that the report was false.
Well, Feldkamp would have looked at those sources, or a reasonable jury could infer that Feldkamp would have looked at those sources.
Is there any evidence of that, though?
That Feldkamp would have looked at those primary sources?
That he did look at the primary sources.
Well,
Is there any evidence that Feldkamp watched the video and then falsely reported the video from which a jury could conclude that Feldkamp knew that his description of the video was false? It's just speculation. You see the issue I have with that?
I understand the issue, Your Honor. I would go back to, for example, the PayPal transactions. They either did or they didn't exist. Feldkamp says they existed and implicate Adams. Adams says they didn't. It's a battle of credibility. One of them has to be incorrect. One of them has to be knowingly wrong.
But that's not enough to establish a trial, at least under our current case law. That we'd have trial every time there'd be a trial in a retaliation case. Every single case.
So
every defendant would be entitled to a trial.
This is a little bit of a unique case because it's not, there's the timing, which on its own is not enough. There's combined with the parts of the report that I think, whether it's enough for trial is different from whether it's enough to create a dispute of fact about whether he knew at least aspects of the report were false.
The timing probably hurts you here. It's not only that it's not enough, it probably hurts you because of the timing. Feldkamp conducts his investigation and files his report long after the ombudsman report was filed. He conducts a careful investigation. This is not a timing thing where we see like a reactive punishment in retaliation. For the timing here probably helps the state.
I would say there's a dispute of fact about whether the investigation was careful or whether they were just out to get Adams, particularly because he was implicated quite early on. I think it was just a couple days after the February 5th assault is when Feldkamp, said the injured offender implicated Adams. So this is 2-3 weeks after, the February, or after the ombudsman complaint was filed. And you also had the oddity of these charges kept not sticking and then they kept coming back. I mean, he was in solitary doing these internal appeals. This came up in the Gale case too, about the fact the charges were not sustained as additional evidence a jury could look at and say something went wrong here. I mean, you're talking he's in solitary.
I'm not even sure that would be admissible at trial, by the way.
That the fact that the charges were not sustained.
Right. I'm not sure that's admissible evidence. I don't think that has anything to do with retaliation. That could be all kinds of reasons for that, including that he was getting out of prison.
It could be all kinds of reasons.
That would be a total
we just don't
side
know.
issue.
Did anyone else have any other questions?
Is there anything else you needed to add?
And just briefly that, the state has conceded, there's a question of whether he received due process, that the disciplinary hearings were directly tied to the disciplinary segregation. They sort of conceded a neutral review is needed. And I think that on this record, there's at least a question of fact.
Thank you so much then. Case will be taken under advisement.
Thank you, Your Honors. Thank
you both very, very much. All right, we go on to case number 4, 2212. All right. $1272, Cara Ross versus Financial Asset Management Systems. Mr. Camarena.
Your Honors, opposing counsel, may it please the court. My name is Bob Camarena, and I am counsel for the appellant in this case, Ms. Cara Ross. Ms. Ross raises essentially 3 issues on appeal. Unless the court has another preference, I would like to start my arguing by addressing the issue regarding the bona fide error defense in this case.
I would like to ask you something. In terms of the failure to cease efforts to collect the debt, why isn't the debtor the appropriate plaintiff here rather than Ms. Ross? In other words, you.
Yes.
It's the debtor, after all, who triggers the protection of the statute by disputing the debt. Although Ms. Ross was the recipient of the call, there didn't seem to be any effort to collect the debt from her. If you brought the claim, on the other hand, couldn't you rely on the phone calls that your wife received?
Absolutely, Your Honor. The debtor is an appropriate plaintiff, but the debtor's wife was also victimized, and she's also within the scope of protection that this court has talked about in Todd versus Collecto. she also stands in the shoes of the debtor. Your Honor, in Todd versus Collecto, this court stated that non-debtors can bring claims individually on their own in addition to debtors, as long as they stand in the shoes of the debtor.
That is an
So
awfully
your
broad reading.
position, is it your position that even a total stranger to the debtor who receives a phone call, maybe it's someone with a similar name, has standing to sue under 1692 GD? Could Congress have really meant to authorize so many suits? My God, we'd be inundated. That's all we would have time to hear.
Yes, Your Honor, 1692 GB, by its very terms, doesn't limit the plaintiff. Other sections of the Fair Debt Collection Practices Act specifically limit who the plaintiff can be. 1692 GB doesn't state that this applies only to the debtor.
But it talks about the consumer, and you're relying on the Todd case.
Yes.
And the Todd case was interpreting provision F. It
Yes.
was not interpreting the same provision.
Yes.
And in fact, when the Todd case interpreted B2, which had similar consumer language only, the Todd case found that that was limited
Yes, Your Honor.
to the consumer, to the
Yes.
debtor, not to anybody.
Yes.
So I don't think Todd helps you.
Okay, Your Honor, I think the statutory language by itself supports this case, and
How? Because it talks about if the consumer notifies. It doesn't have some of the broad language that we've relied on in other provisions.
Your Honor, the language of the statute says, if the consumer disputes the debt collector shall cease collection of the debt. Full stop. It doesn't say it shall cease collection of the debt as to the consumer. It says it shall cease collection of the debt. That means that Congress didn't mean to limit the victims who can be victimized after the consumer disputes the debt. Of course, clearly, only the consumer can.
Mr. Caminero, can I ask you a question? Because it seems to me you wanted to address the bona fide defense to start with, and I'm interested in that because what you did here was your wife was notified of the debt, and then you sent an email to the CEO of the company. You deliberately did not follow their procedures, right? You sent CEO. You sent the CEO an email. You looked up his email address. It seems like you're kind of, it's a game, right? You're going to send the CEO an email and then say, well, they're on notice, when the CEO says, I had no idea that I received that email. And then you say, aha, and they still contacted my wife. Isn't that exactly like the dictionary definition of a bona fide defense?
Your Honor, I received a letter that was signed by Mr. Kevin H.S.
Was his email on there? Did it say, email me, the CEO of the company, if you dispute this debt? Could you imagine a world we'd live in, like what Judge Rovner was getting at, where that was the process by which you disputed debts? And once you email the CEO of the company, no matter how big the company is, no matter where in the world it's located, that's it. The company can do absolutely nothing else to attempt to collect a debt. And if they do, they get sued.
Your Honor, I didn't just email the CEO. I also emailed the Vice President, who was the person who sent a letter to me.
But why didn't you follow the procedures that they told you to follow?
Your Honor, I didn't.
You're a trained lawyer.
I understand that, Your Honor, and I also I understand that as a trained lawyer, you're likely to get a more appropriate response when you go to the top.
Really? If I had a question, like IBM, I should just email their CEO and ask,
Your
and
Honor,
he's going to respond. I doubt it, especially when they say, follow these procedures. I mean, I think Judge Rovner is right in part. I think we'd need another circuit to deal with these types of cases if that was not a bona fide defense.
Okay, Your Honor.
Go ahead, I'm sorry, you can continue.
Ms. Ross also raises other allegations that the debt collector violated the act. Aside from...
Yes, the fact that Ms. Ross has a potential remedy under D, Section 1692D, for intent to annoy.
Yes, Your Honor. And I was going to get to that.
Would that tend to confirm that she lacks standing as a non-consumer for the failure to cease collection efforts under G? In other words, she has other remedies here.
She does have other remedies, Your Honor, especially because D5, under which she brought a complaint, specifically says that it applies to any person at the number called. And with respect to D5, the debt collector knew that it was trying to contact the debtor, Mr. Cameron.
But you agree if they're entitled to the bona fide error defense, she can't prevail on her D claims either.
No, Your Honor. Well, if they are entitled to...
If they're entitled to the bona fide error defense.
The bona fide error defense will preclude any recovery, but the bona fide error defense should be evaluated as to both G, 1692G, and separately as to 69.
But we don't have to get to it on G if there's no statutory standing to bring that claim.
That's absolutely correct, Your Honor. The court should consider it if there's if Ms. Ross has a claim under D5. And importantly, with respect to D5, Ms. Ross told the debt collector that her number was, quote, not an appropriate number for Mr. Cameron. And they continued calling. Then she went on she received another call from the debt collector, and the debt collector asked for Mr. Cameron's phone number, and she specifically stated, quote, I don't want to give out Mr. Cameron's phone number. And they continued calling.
But she said she would pass the information on to you.
On one occasion, Your Honor, on one occasion, and they called...
I think it was that second call.
No, Your Honor.
Or the first, I thought it was the second that she answered, that she said she would pass it on.
She said it on the first call, Your Honor, and she was called 11 times after that. And the second time that she answered the call, she specifically told him, I don't want to give out his phone number. And the debt collector continued to call. So now his question, Your Honor, is why would they continue to call when they know they're reaching someone who doesn't want to give out that phone number?
The debt collector put in information, put in evidence that they have specific procedures in place. What evidence is there to dispute that they had those procedures in place? Specifically, if somebody received an email complaining about calls, or if they called the wrong number and they weren't supposed to call back. I didn't see anything from you disputing that they have those procedures in place.
This is right, Your Honor. My position is that those procedures, which are essentially establishing a computer program that will prevent illegal calls and training their folks on that computer program, is reasonably adapted to prevent any violations. I disagree with that, and the court would allow me to. I'd like to quote Judge John Tharp in another.
Well, I'm looking for this particular case. I understand what your argument is, but what evidence did you put in to dispute those procedures?
Your Honor, I'm not disputing that those procedures occur.
Okay, so you agree that they have those procedures in place?
Yes. My disagreement is whether those procedures are sufficient to maintain procedures that would reasonably prevent any violations. I see that.
Thank you.
I've run out of time. Unless the court has any questions, I will cede my place to opposing counsel.
Thank you very much. So, Ms. Strickler? Yeah.
Good morning, Your Honors. May it please the court, my name is Nicole Strickler, and I'm here today representing the defendant appellee, Financial Asset Management Systems. As I think...
Had Mr. Camarena been the plaintiff here, do you agree he could have relied on the phone calls to Ms. Ross to support his claim under 1692 GD?
I think it's abundantly clear from the statute, the plain language of the statute, that the consumer is the appropriate party to assert a claim under 1692 GB. Congress knew when to use the word consumer and when to use the word person. and did so through different portions of the act when they were trying to curb certain types of conduct. In fact, if you look at 1692 CB, Congress actually defines consumer relative to that section to include the spouse. So I think that if it was true that that a third party, Congress intended a third party to have standing under 1692 GB, they knew how to do it, and they didn't do it here. And I also think it's telling that there's absolutely no case law to ever support that a 1692 GB claim could be asserted by anybody else other than the consumer. So to
I
me,
suppose Ms. Ross were Mr. Camarena's former spouse, or perhaps even a stranger to him, and yet FAMS kept calling her. Why should she not be able to claim the benefit of 1692 GG, even though she has no responsibility for the debt? She's still suffering an intrusion into her privacy and solitude, isn't she?
well, I think, Your Honor, that section, that what Congress intended that circumstance to cover was under 1692B, which deals with third parties and actions, debt collection activities that would involve third parties, which is limited to that location information sort of scenario. And so, I think you look at the language of B, you look at the language of C and G, and G was just not intended to cover third parties. It's just not in the language of the statute. So from a standing perspective, from a statutory standing perspective, really, the GB claim, it doesn't hold any water. And then secondarily, we have the factual reality that none of the executives that counsel emailed ever were notified that there was a request for validation. Two of them had absolutely, after searching their emails, couldn't even locate the purported email. The third found it in a deleted folder, had absolutely no recollection of ever seeing it. And I think if you look at, again, the text of 1692 GB, and you look at the fact that Congress said notify the debt collector in writing, it's not what happened here. Now, if he would have mailed the notice to to financial asset management systems, he could have relied on the mailbox rule to prove the notice. If he would have taken some sort of other action to notify.
You don't think email qualifies for in writing?
Well, I suppose I would say it is in writing.
You would, or I wouldn't? I'm sorry.
Well, I think it's in writing. However, nobody saw it. Nobody got it. So I think that's the evidentiary point. I'm not sitting here saying if the consumer actually sent it, someone looked at it, that wouldn't constitute notice in writing, I think, in today's time frame. But that's just not what happened here, and I think that's the underlying problem. And then, third, you have the bona fide error defense on the GB claim too, which is that the executives were trained what to do if they inadvertently received this sort of correspondence, how to route it so that the account could be appropriately coded. So I think for all those three reasons, the district court should be affirmed on the GB claim. And if we move to the D claim, I think there's several bases to affirm that ruling as well. First of all, if you look at the pattern and volume of the calls, this is not something that would lead to the conclusion that there was an intent to harass this woman who had offered to take messages and transmit those messages to her debtor husband, and who never asked that the calls cease, who, the transcript of the calls, which is in the record and was relied upon by the plaintiff in the case, shows they were short, they were polite.
What about the fact the statute makes it actionable if the calls had the effect of annoying the recipient? There were 11 calls made within a short period of time, and there's evidence that there were 2 hang-ups during that. And I know you dispute whether or not there were 2 hang-ups.
Sure.
Or who hung up. But why would that raise an issue of fact, at least, as to whether or not the effect was to annoy the recipient?
Harass, oppress, or abuse the recipient, causing the telephone ring to do so. Sure. So I think what the case law shows you is you look at the pattern and the volume of the calls to determine if that's the conclusion, which I think the pattern and volume of the calls does speak to that. In that,
Why isn't that an issue of fact if you have 11 calls?
well, because I think as a matter of law, under these particular circumstances, this was not a situation where there's the natural, well, I shouldn't say natural consequence, but because really this is a 1692 D5 claim where they have to prove intent to harass. And that's not there. There's no intent to harass. So even if you were to say, okay, maybe this would have some sort of, dispute of fact that it potentially could have caused harassment, there is no intent here to do so. The undisputed facts in the record show why they called. And even in the event that we were to forego that entire conclusion and rely on the bona fide error defense, again, there was policies and procedures in place. These sort of policies and procedures are standard in the industry to prevent these sort of claims, where accounts are coded to prevent calls from occurring. Once those codes are entered, the system does not allow calls to go out. So those are exactly the sort of policies and procedures that are reasonably adapted to avoid these sort of errors.
Yeah, but Ms. Ross has argued that although FEMS represents that it had this audit program, it didn't establish how many calls it audits. Without that sort of evidence, can a defendant really claim the benefit of the bona fide error defense? How do we know whether the audit program is genuine or it isn't?
Well, I think we can, Judge Rovner, and I think it's because the testimony of the 30B6 representative who was in charge of compliance testified that there were live audits that were taking place. Now, admittedly, in her 30B6, she could not name the precise number, but I could tell you I sent text messages yesterday, but I don't recall how many I sent yesterday either, and that doesn't mean it didn't happen. To me, it's probably quite a few. But, again, the procedures here have to be reasonable. I don't even think they needed an audit for those procedures to be reasonable, but they had them. And all that testimony is really uncontroverted. And, as indicated by the court, there really was no evidence that was offered by the plaintiff that, we didn't have those procedures in place. They're there. So really, there's no basis to reverse the district court's opinion, and in fact, it should be affirmed. And unless there's any sort of questions the court has for me, I'll end it there.
Okay, thank you.
Thank you very
And
much.
we'll just let Mr. Camarena have the 3 minutes he asked for.
Thank you. Thank you, Your Honor, for affording me these 3 minutes. A moment ago, the court asked about auditing. I tend to agree with the appellee's concession in their response brief, where they say audit procedures are more akin to a procedure designed to identify and correct errors that after they have occurred, rather than a procedure to prevent the error to begin with. So it can't be, the appellee has conceded that an audit procedure is not reasonably designed to prevent any such violation. But even if the appellee had not made that concession, the appellee didn't know whether they audited 1 out of 10 calls or 1 out of 1,000 calls. Certainly, it would make a difference if the security personnel downstairs would have only 1 person out of 1,000 pass through the metal detectors. We wouldn't say by any stretch of the imagination that they have maintained procedures to prevent contraband from entering into the building. The appellee was told beforehand that they would be questioned, that they would be examined about the bona fide error defense. And the subject of audits came up, and they said, we don't have any idea what number of calls we audit. Could be 1 out of 100, it could be 1 out of 10, it could be 1 out of more than 1,000. And I would submit that auditing 1 out of more than 1,000 is not reasonably designed to prevent errors. Aside from that, Your Honors, with respect to the phone calls, of course, the appellee contest that the appellee hung up on Ms. Ross. She testified on 2 occasions that it was the appellee that hung up on her. Certainly, the jury doesn't have to believe her. A jury can listen to her testimony and say she's not credible. The appellee did not hang up on her, but a jury can believe her. A reasonable jury can believe her and can find that the appellee hung up on her on at least 2 occasions. Importantly, the appellee did not raise the issue of the bona fide error defense with respect to the hang-ups. They simply asserted that it never happened, so the appellee doesn't have to deal with it. So the appellee can't rely on the bona fide error defense with respect to the hang-ups. Thank you for the additional time that the court has given me. I appreciate it.
Thank you both for your arguments, and the case will, of course, be taken under advisement. Thank you. All right, we'll go on to case number 5, appeal number 22-2032, Dr. Quintella Bounds versus Country Club Hills School District 160. Hello, Mr. Davis.
Good morning, Your Honor. Good morning, judges. May it please the court. My name is Jerome Davis. I represent the plaintiff appellant, Dr. Quintella Bounds. We believe the district court committed reversible error with regard to Dr. Bounds' due process claim because it failed to consider whether state law, specifically section 23.8A of the Illinois School Code, was a predicate for her due process claim.
Mr. Davis, can I just confirm with you, please, what precisely you're basing your client's property interest on? 'Cause I think you agree, in order to have a due process claim, you have to have a protected property interest.
Yes.
And are you basing it on the February 20th evaluation? Are you basing it on the board vote? Are you basing it on what you've just cited, 23.8A of the code? I was a little unclear from the briefing what your precise position was.
My precise position, Judge, is that it has 2 sources. One is the March 24th, 2020 vote, which we say was pursuant to section 23.8A, and by that statute vested my client with a contract. It was an oral contract. We presented evidence that an oral contract was negotiated in February of 2020, which was ratified by that vote. The second source is the mutual understanding between the parties based on the past practices and the communications to my client, similar to in Higginbotham, where my client was told that the only thing that was required to renew her employment was a vote by a board majority. So again, we believe the March 24th vote was consistent with her reasonable and legitimate expectation, which made her believe that she had an entitlement to continued employment.
As I understand it, the board postponed the votes on the administrators from March 17th to March 24th so that the written contracts could be revised. Don't we have to ignore that context in order to accept Dr. Bounds' assertion that what the board approved on March 24th was her continued employment generally, rather than the written contract that was subsequently mailed to her?
Judge, we actually don't know what the board did on March 17th because the board didn't do as it was required by law to make a verbatim recording of that meeting. We know that defendants are now saying that that vote was postponed because they wanted to consider a written contract. But our position is that there's a fact issue that my client had a negotiation with the superintendent in February. They came to terms, and that she was told on March 24th they would vote. My client also, I'm sorry.
I'm going to stop you there, because if Superintendent Scott only had the authority to recommend that Dr. Bounds' employment be renewed, how could Superintendent Scott and Dr. Bounds reach any sort of enforceable understanding as to the terms of her employment? In other words, I mean, wouldn't the board have to know what terms Superintendent Scott had offered to Dr. Bounds, and moreover, approve those terms?
Precisely, Judge, and that's what my client testified to, is that what the superintendent told her was coming from the board. The board made promises that she would have a contract renewed on the terms of the prior year contract, and the superintendent was relaying that. We also presented evidence that the
But she didn't have the authority. She had the authority to recommend that, but she did not have the authority to approve that. Only the board, it would seem, had that authority. That's the problem.
We presented evidence, Judge, that in this district, the superintendent negotiated the contracts. The superintendent negotiated my client's original contract in 2019. This case is on point with Vail. The superintendent was relaying to my client the promises that were made by the board. And we also presented evidence that there was a collaborative process. It wasn't a process where the superintendent came to a evaluation and said, well, I'm going to make a recommendation. If you're going to talk to somebody about whether you want them to come back the next year, you got to be able to come in and tell them what the terms are going to be of their employment. How much are they going to get paid? Are they going to have the same vacation? We gave evidence that before the superintendent met with my client in February, she met with the board, that was their practice, and that the board told her then, these are the terms that we're going to offer, and that's what she relayed to my client in February. And then my client resisted at first. She wanted a raise. She thought she was entitled to it. But the superintendent assured her, we're not going to give raises, but everything else will be the same. That was an assurance from the board. My client then said she accepted that, and she was told, based on the past practice, that the March 24th vote would be a ratification of that agreement. So we also believe the court erred, Judge, because with regard to the issue of mutual understanding, and even, let me back up even before I go there. This court said in Shelley, when you're going to talk about whether there's a cognizable interest, you've got to start with the statute, with state law. And here, the judge ignored the statute that governs employment of administrators. He only talked about it in a footnote in passing, and he talked about it and he said without deciding it. So we think that's a reversible error in and of itself. The court couldn't possibly rule defendants were entitled to judgment as a matter of law without considering the governing statute.
And you're referring to 23.8A when you say the statute, correct?
Yes, Judge.
And what is it in the language of that statute that you think suggests that a board vote is all that is needed to renew an administrator's contract?
The statute says that the board may only hire an administrator under a contract for 1 year or a performance-based contract for up to 5 years. This court has ruled that any time a governmental entity gives a contract for a fixed duration, that gives rise to a protectable property interest. So
but
if
the
board,
the contract that was entered had expired.
right, but the
So
new
how-
contract, they voted on a new contract.
But that's what I don't understand. Where is it in this section that says that the vote alone would give that property interest?
Because it says the only way you can hire an administrator is pursuant to a contract.
Right, and there's no contract if both sides haven't signed it here.
Well, there was an oral contract that the parties agreed to. And as the district court acknowledged, the statute permits oral contracts for up to 1 year. So there was an oral contract negotiated in February, and that's what the board voted on. So if the board came in March 24th and said, we hire or we're renewing Dr. Quintella Bounds, by virtue of the statute, they just hired her, they were required, they can only hire her for a contract, under a contract. And that meant she went from being an at-will employee to an employee with a contract. That gave her a cognizable interest. So the vote itself, which was supposed to, based on what she was told, ratify what she was promised in February, gave her a contract. Moreover, we presented evidence like in Higginbotham and Sinderman, and the court in this case treated that evidence, said that it strained credulity, said that it was implausible that my client could believe, based on the past practices, that she had an entitlement. As Judge Posner said in Architectural Metals, if you read the court's opinion, it doesn't read like summary judgment. It reads like a trial. And this court's well-established precedent is that summary judgment is not a trial. Weighing evidence, making credibility determinations is left for the jury. And we believe that the court erred because it did not do so in this case. And unless there are other questions, I'd like to reserve the balance of my time for rebuttal.
Well, you used all of your time, actually.
Okay.
But I
Thank
will
you,
give you
Your
a
Honor.
few minutes.
Unless-
I will give you a few minutes.
If the court has any further questions, I'll
Thank you.
answer them. Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, my name is Jennifer Schwandenner and I represent the defendants. Briefly, I'd like to touch upon a comment that counsel made with respect to Section 10-23.8A of the Illinois School Code. Nowhere in that statute does it give plaintiff or any administrator substantive due process rights. What it simply says is that the district may only employ school administrators under a contract for a period not to exceed 1 year, or a performance-based contract for a period not to exceed 5 years. Nowhere in that statute does it give plaintiff any due process rights. This case is analogous with Liznicki versus Board of Education of 167. In Liznicki, the plaintiff was a principal and employed under a yearly contract, which expired in June of 1980. The defendant Board of Education voted in February that year to renew Mr. Liznicki's contract for the following school year. Importantly, the plaintiff never signed that offer, or never signed that contract. In June, the board changed its vote and directed the plaintiff's contract not be renewed for the following school year. Plaintiff was not provided a hearing. The Seventh Circuit affirmed the district court's granting of summary judgment in favor of the defendants and ruled that plaintiffs did not have a right to continued employment as a principal under state law. The court held that plaintiff could not base such a right on a contract. He only had a yearly contract and it was not terminated at the end of that contract. The court noted that plaintiff had plaintiff signed the contract with the board for that following school year, and had the board broken that contract, plaintiff would be able to complain of a deprivation of a property right. But since plaintiff never signed the contract, all we had was there was an offer and never any acceptance. Here we have a remarkably similar fact pattern. The record evidence unequivocally establishes that the board vote on March 24th, 2020 was to extend an offer of employment to plaintiff and 5 other administrators for the following school year. All administrators, including the plaintiff, were notified that evening by Dr. Scott, the district superintendent, that their contracts would be forthcoming the following day and they had to sign and return by March 31st. Dr. Scott did email the contracts the following day, again with directions to sign and return by March 31st. It is undisputed that plaintiff never signed that contract. She never returned that contract. As such,
do we know whether the board was made aware that Dr. Bounds was ill during the week, that she had to review and sign the contract?
The board was not, there's testimony in the record to establish that the board members were not aware that plaintiff was sick. But the record evidence does establish that Dr. Scott was aware that plaintiff was out at that time. regardless of whether plaintiff was sick or not, she was still communicating with Dr. Scott and the board. She did receive the email, but she did respond to that email, which directed her to sign and return the contract by March 31st. And plaintiff did testify that she did receive the contract and did receive that email. So it is undisputed that she was aware that she had to sign and return the contract by March 31st. Turning to an issue that plaintiff heavily relies upon is whether Dr. Scott made an oral promise to plaintiff and whether there was an oral offer of employment during plaintiff's performance evaluation on February 24th. As the court noted, Dr. Scott did not have authority to bind the board. Under Illinois law, Section 10-21.4 of the school code, in the board's own policy, Section 3:50. The superintendent at most can make recommendations to the board, but the superintendent does not have authority to bind the board. We cited two cases in our brief that hold that a superintendent is under the direction of the board and has no authority to retain or dismiss principals or to determine salaries. Coleman versus St. Louis and Wolf versus City of Fitchburg. Wolf held that a mutually explicit understanding which constitutes a property interest cannot be based on the representation of government officials who are not authorized to make such representations. Here, it was clear that Dr. Scott's authority was limited by the Illinois school code, and the board's actions clearly expressed its intent to offer terms that differed from plaintiff's prior 2019-2020 contract. The testimony of Dr. Scott, board member Sharon Mack, and board president Jacqueline Doss, and even plaintiff's own testimony confirms that Dr. Scott told plaintiff she would be renewed for the following year. This is further consistent with all actions taken by the board during the March board meetings, in which they considered which contracts they wanted to renew. They intentionally made changes to those contracts by modifying the vacation time, and they voted to improve employment agreements for plaintiff and the 5 other administrators. The employment agreements differed from the prior years. That was an intentional change that the board made and voted on that evening on March 24th. The board then directed Dr. Scott to email the contracts to plaintiff and the other administrators with explicit directions to sign and return by March 31st. Plaintiff even concedes that this process, the superintendent making recommendations to the board on page 19 of her appellant brief, when she discusses the circumstances of her hiring with Dr. Goodsell. In her brief, she cites that plaintiff negotiated her contract terms with Dr. Goodsell, and that Dr. Goodsell said that he would recommend that the board approve her contract. Plaintiff further states in her brief that this process was repeated again for the 2020 school year when plaintiff allegedly negotiated the contract with Dr. Scott and made a recommendation to the board. Even if we adopt plaintiff's testimony regarding that February 28th, 2020 meeting, there is no evidence that Dr. Scott was directed by the board to make any offer of employment to plaintiff. Plaintiff did not testify that she accepted any such offer or took any actions in reliance upon an offer that Dr. Scott had allegedly made. Plaintiff cites and relies heavily on Vail versus Board of Education, which is very distinguishable for the facts in this case. Vail, there was clear testimony that the board expressed a clear desire to hire plaintiff for 2 years. And the board further instructed the plaintiff to take action and to notify the plaintiff of their expectations that plaintiff would be hired for 2 years. Plaintiff relied on that, quit his job, moved his family, and took a salary cut in reliance on that offer of a 2-year employment. Here, there's no evidence that the board directed Dr. Scott to make any offer to plaintiff. To the extent that Dr. Scott suggested as much, she certainly did not do so at the direction of the board. The board unequivocally offered a revised contract, which demonstrates its intent to modify the terms of her contract for the 2020-2021 school year.
Dr. Bounds has submitted evidence that there are other employees who were able to work without a written agreement in place. What impact does that have on your argument?
Any alleged past practices of the board are relevant here because it does not establish a mutual, explicit understanding that supports a claim for entitlement. A plaintiff had, if at most, it would establish a plaintiff had unilateral belief that her employment was secure. The plaintiff cannot establish that the board had a similar belief. Any purported past practices again, are undermined by the fact that the board took specific action to offer plaintiff an employment contract with specific terms for the 2020-2021 school year. That contract, the board directed Dr. Scott to convey that offer to plaintiff with instructions to return and sign by March 31st, which plaintiff did not do. The last point I wanted to briefly make was that even if plaintiff has established or can infer that Dr. Scott had authority to offer her, or that the board somehow ratified a one-year promise made by Dr. Scott, it still does not give her a protected right, property interest in continued employment. Plaintiff's 2019-2020 contract was at will. Paragraph 6 of the contract explicitly states that either side could terminate without cause, and that she was an at-will employee. As held in Kerr versus South Cook Intermediate Service Center, a contract for employment not to exceed a certain period of time, which we had in her contract, suggests an indefinite period of employment which under Illinois is considered at will. In Cromwell versus City of Monmouth, the Seventh Circuit hurled that at-will employment cannot form the basis of a legitimate expectation of continued employment under Illinois law. So even if plaintiff could establish that the terms of her contract were renewed, she cannot establish that she had a protected property interest in continued employment. Based on those reasons, we respectfully request that Your Honors affirm the district court's granting of summary judgment.
Thank you very much, Mrs.
Thank you.
Ms. Schwendener.
Thank you, Your
And as I said, you had used all your time, but Mr. Davis will give you 3 minutes.
Thank you very much, Your Honor. Counsel's argument sounds like a closing argument in a trial. I remind the court that this court, just as the district court, is bound by the rules of summary judgment. And in those rules, all inferences drawn from the evidence must be drawn in favor of the non-movement. And the summary judgment proceeding is not a trial. I don't see how you can reconcile what the district court did in this case, where the issue in Vail was whether that promise for a second year to renew the contract, which was conveyed to the plaintiff through the superintendent, was made. That was the issue in the case, and that had to be resolved at a bench trial. I don't see how you can resolve that with the district court, which, by the way, in this case, identified at the outset in the motion to dismiss that there were 2 factual issues. One was the March 24, 2020 vote, a vote to hire plaintiff pursuant to the statute, and the second was whether or not there was a practice in the district that the only requirement to renew employment was a board majority vote. The court identified those as factual issues. However, then at summary judgment, it proceeded to resolve those issues. That's totally antithetical to the statute. And counsel keeps saying there's no evidence that the promise was made. This case is distinguishable from Coleman. In Coleman, there was no evidence of a promise made by the board. Here, my client has said that the superintendent told her, the board said, we're going to renew you on the same terms as the previous year. That's a swearing contest. Swearing contests, as this court ruled in Ziccarelli, don't get resolved by this court or the trial court under summary judgment. That's a factual dispute. And as far as the statute itself, not giving a positive right, the statute says the only way you can hire somebody is by a contract. So if there's a board, and the only way the board can take action is via a vote. So if the board has a vote and it says, I hire Jerome Davis, then by the statute itself, that created a contract. This court's authority says, once that happens, a cognizable due process claim arises. And so we think this case is clear. There's clear factual disputes that abound. With regard to the evidence, counsel saying it's no evidence. We had 2 employees who gave evidence, the same evidence like at Higginbottom, that they were told, don't worry, a board vote is all you need and you're hired. And the district court said that was anecdotal evidence. The district court entered into determining the credibility. And therefore, we think the court committed reversible error, and I thank the court for the additional time.
You're very welcome, and thank you, Mr. Davis, very much, and thanks to Ms. Schwendener again. Case will be taken under advisement. We will go on to the last case of the day. Case number 22-1447, United States versus DeAndre Smith. And Mr. Rosen.
Good morning, Your
Mr. Rosen, you and Miss Boyle are a regular team, a tag team.
It saves time and trouble of coming back again and again to do this with both of us. Good afternoon, Your Honor. It's now afternoon. Once again, it is our position that the trial court abused its discretion. The trial court had clear knowledge of Dean's procedure that Justice Roberts laid out in the case of Dean and did not follow it. Trial counsel had advised the trial court of Dean's existence and had advised, I think, in the written memorandum and in court that they should be packaged together. And what the court did was basically, and I understand the court, with respect to the sentencing guidelines for the predicate offense, went under the guidelines. I know this government's going to make an issue about that, and I was anticipating the court's going to make an issue about that. They did go below, but the court did not follow the edicts of Dean, which Justice Roberts reversed and remanded back to the trial court for.
Is there anything in Dean that requires the district court to explicitly say that it was considering the sentence in totality?
The fact, I anticipate that. I think the fact that the court, Justice Roberts remanded the matter back to the district court for procedures consistent with the opinion, I think was his exact language, after he basically laid out the language, and Dean, that there's nothing in these requirements prevents a sentencing court from considering a mandatory minimum sentence or 924C when calculating an appropriate sentence with predicate offense. And then immediately thereafter, Justice Roberts reversed the court of Eighth Circuit and remanded the matter for further proceedings consistent. So I think that is what we're looking at in terms of how that would be approached, Your Honor.
We have this unpublished opinion, United States versus Wilson, from a few years ago, and in that case we wrote, nowhere does the court say it was bound to apply the career offender guideline in the sense of an obligation to oppose a sentence within that range. The court simply followed the rule that every sentence must begin with the accurate calculation of the advisory guideline range. It's kind of exactly what happened here. I mean, maybe we need to publish something that says you don't have to explicitly reference Dean, but I just wonder if there's a distinction between, if we were in a world where the court said, I can do this, I can do this, I can do this, but I declined to do all those things in order to affirm the district court on sentencing to help, to establish the district court knew what it was doing. Boy, that would be a long list, and it would get longer and longer and longer every term.
Well, the thing is that in this case, Judge Mim never even discussed Dean. He never talked about it.
Isn't it clear, though, that he knew he could consider them together by the fact that he went down? He downward departed on the first part, or he gave a lower sentence on the first part. He didn't go within the guidelines.
I don't know.
It seems to me that that's an implicit acknowledgement that he.
I don't believe so, because he didn't word it that way. He said, I'm giving 60 months on the predicate offense, and then just tacking on the 60 months for the 924C. So he never really addressed that. He also, as I indicated in my briefs, didn't fully address all the mitigating factors that he should have done. I think he didn't address
Based on the record, what would you rank as Mr. Smith's top 2 or 3 arguments in mitigation?
His rank, I think that he, I didn't rank them. I had a number here. He was a lack of a violent history. The firearm offenses he had previously were merely possessory. He'd been previously shot. He could not take classes. Danville is a dangerous area. I think that came out during the trial. There was no the 2 prior offenses that had been involved in this series of offenses that he pled guilty to had no evidence of firearm possession. There's a whole number of issues there that I think when you look at it, like I said, Your Honor, I didn't rank them. I just think that they are all relevant. And I think Vizcarra talks about failure to consider relevant mitigating factors is an abuse of discretion. And I think there is nothing that mandates that the court should consider Dean, but I think there's also nothing that says that the court should not consider Dean. And I think when you look at the Justice Roberts specifically remanded the matter back to the district court for considerations based upon Dean, saying, I think that basically leads to his understanding and his communication that Dean is to be considered. And like I said, Judge Mim didn't even talk about it. He didn't say, I'm considering Dean, I'm not considering Dean, I'm not doing anything with Dean. He just sort of did the 60 months, figure that out, and then just piggybacked on it. And I think and I think when you look at the total of what Mr. Smith was deserved, I think it was in line. When you look at the 3553A, which I think basically Dean is relying upon now, as opposed to just basically doing the guidelines after the case law, was the 7 years that trial counsel asked for, which was basically what was still not, it's still 2 years for the predicate offense. He had the drugs. I think there were small amounts of drugs, very small amounts of drugs. He was basically using this to basically keep himself alive. Those sorts of factors were going on. But I think when you look at Dean, and also Dean, basically Judge Roberts said nothing in the language of 924C prevents a district court from imposing a 30-year mandatory minimum sentence under 924C and a one-day sentence for the predicate violent or drug trafficking crime, provided those terms run one after another. That's page 498.
Mr. Rosen, you've argued that the court didn't consider I'll just take two examples, the small drug quantity or the carrying of the gun for protection. But the court specifically stated, defense counsel has noted the small amounts of drugs involved. It was indeed fentanyl, which is very dangerous, and I'm troubled by it. And then with respect to the carrying the gun for protection, the court acknowledged that the gun was there to protect him and his drugs, and that it may also be true that Danville is a dangerous place. But the court found that Smith had contributed to the danger and wasn't persuaded by that. So I don't understand how you can argue the court didn't consider that. I understand you think the court should have weighed it differently, but that's not for us to decide.
No, and I understand. I think the court did consider that, but I think the court also did not consider some of the other factors I indicated, the lack of violent history. He was not the target in this thing. Mr. Smith they were interrogating him about his other people involved. They were basically using him to try to go along. He was cooperative upon arrest, no history of violence. I think there are other factors that the court did not consider that I think should have been considered, I think would have if the judge had done this correctly as we believe when following Justice Roberts' opinion on this, would have basically given the 7 years, I think, which is what was appropriate, but by basically doing what he did, basically trying to give him a favor by saying, I'm not going to give you the 92 to whatever it was, 110 months on the front end of the predicate, instead of giving you 60 months on the predicate and giving you a break, but then tacking on the 60 months for the 924C, really didn't do what it was supposed to do based upon the case law that I've got here. If there are no other questions, I'll reserve my time for rebuttal.
Thanks so much.
Good morning again, Your Honors. May it please the court, counsel. My name is Catherine Boyle on behalf of the United States. Judge Rovner, you alluded to during my opposing counsel's argument the number of issues raised regarding this sentencing. And I think what we first want to do here is pull back and acknowledge that the overall picture in this case is of a district court, an experienced district court judge who took great care with all of Mr. Smith's arguments and in going over his objections and the guidelines. The court...
Well, as I read the sentencing transcript, there were several arguments in mitigation that were not addressed explicitly, and, absent confirmation that the judges addressed a non-routine mitigation, shouldn't we remand in these cases if we don't have confidence that an argument was really considered.
Well, Your Honor, the district court is not required to address arguments that are stock arguments or frivolous. And in this case,
I didn't, of course not. I'm talking about the non-routine mitigation arguments.
certainly, Your Honor. And would it be most helpful for me to go through the arguments Mr. Smith has raised, or is there any one in particular you'd like me to address
Well,
first?
why don't you do that, and let's see where we come out.
Sure, Your Honor. So following this fulsome explanation of its sentence, Mr. Smith has raised the argument that the district court failed to address a variety of issues during sentencing. He first argues that the district court failed to consider the small-scale nature of his drug dealing. As Judge Saini pointed out, the district court directly addressed that. The court said, however, it was concerned that fentanyl was one of the drugs at issue, and it was more concerned that this drug dealing was occurring with a loaded firearm. So the court emphasized that it was really the combination of the loaded firearm and narcotics as opposed to just the narcotics themselves. Criminal history. The court went over Mr. Smith's criminal history very carefully. The court, first of all, wasn't even required to address Mr. Smith's argument that his criminal history was nonviolent. That's more or less a stock argument that it's overrepresentative. But in any case, the court did address his criminal history. It went through each of Mr. Smith's priors. It actually dismissed the importance in terms of any violence potential of the juvenile conviction for explosives. And it said it was most troubled by this repeated use of this repeated drug trafficking and firearm possession as a felon. The court also specifically addressed Mr. Smith's argument that he just had the firearm for possession against the dangers of Danville. The court, first of all, that ignores the idea that the jury here had already decided Mr. Smith had this firearm because in furtherance of a drug trafficking crime. So that's sort of an initial step. But second of all, the court did also squarely address this during sentencing. The court believed that Mr. Smith had a gun for protection, but said that was partly because he was walking around carrying drugs and cash, and said that somebody might target him for those. So it is people like Mr. Smith who are making cities like Danville more dangerous by walking around and dealing drugs with a loaded firearm with a large capacity magazine. The court did not discuss in depth this argument that the base offense level was unfairly elevated due to Mr. Smith's possession of that large capacity magazine. That argument was without merit. The guidelines are very clear on this point, and Mr. Smith tried to make a big deal about the idea that this magazine was standard issue on the particular weapon that he had. But the problem with that is there's a lot of weapons. First of all, Mr. Smith is a felon and shouldn't have a weapon at all. But there's also, as opposed to his specific issue with this type of weapon, it's not the only weapon around. And the fact that it was standard issue, really, there's no reason not to apply the guidelines in this case for that reason. Mr. Smith also says the court failed to address the fact that there was no evidence he had a firearm in prior drug deals. I don't think the court needed to address that. There was nobody ever said that Mr. Smith did have a firearm during prior drug deals. He was only charged with drug offenses for the 2018 and 2019 controlled buys. So there's no evidence here that anybody even had that on their mind at the time. Mr. Smith argues that the court failed to discuss his cooperation during his arrest. First of all, you have to think about what is meant here by cooperation. Mr. Smith made a partial admission regarding his drug trafficking, but it certainly wasn't complete or fully honest, and he didn't start providing additional information regarding other prosecutions. He just made a partial admission regarding his own guilty conduct.
Did he raise that at sentencing? I didn't think he raised his argued cooperation as mitigation during sentencing.
I don't think so. There's a chance that he said something very brief along the lines of, he had immediately. But I don't recall it immediately, Your Honor.
Okay.
Something very brief along the lines of he had, admitted his conduct, but that would also go more towards his guilty plea to 4 of the 5 counts. I think that was more of a focus. Mr. Smith noted family support. This court has described that as a stock argument that is common to many defendants. And the court did briefly note that it had read his letters of family support. I don't believe anything more was needed on that count. Mr. Smith also said that the court needed to consider that he was ineligible for certain recidivism reduction programs. That is also a stock argument that would apply to many defendants. Certain 924C defendants, for instance, are not eligible for certain First Step Act programs. But the court didn't ignore the issue of things he hoped that Mr. Smith would do in prison. In fact, the court expressed hope that Mr. Smith would take educational and vocational classes, so clearly was considering.
But he can't.
Well,
he can't take courses that, he would benefit by here. That's the problem.
Well, my
Court
understanding.
is saying, I hope you'll take advantage, but the sentence is such that he is not going to be able to. So that is part of the problem, isn't it?
Well, my understanding is that Mr. Smith was eligible for some classes. I don't think that I would want to double check with BOP to make sure I'm stating this accurately, but I don't believe having a 924C conviction precludes you from eligibility for any class. And I think part of the issue is whether you can get good time credits for your participation in certain classes, even more so than whether you can participate.
I thought that was the issue. Unless something has changed. I didn't think a 924C conviction precluded you from taking educational or vocational classes.
I think
that it was just this credit.
Yes, Sharon. I think it's precluded from participation as a person getting good time credits in the program.
But
more
not
so
in
than-
the actual classes themselves.
That's my understanding, although I would want to confirm, but I believe that's correct. And then I think as for the last point that defense counsel was making today, there's ample evidence from this case that the court was aware of its discretion under Dean. As Judge St. Eve noted, I think it's implicit in the fact that the court varied significantly below the guidelines and imposed a sentence of 60 months on the 4 non-924C counts and an additional consecutive 60 months on the 924C count. And it said that that was sufficient but not greater than necessary, which I believe shows that the court here was considering that it didn't express any regret and say, I'm bound by this consecutive 60-month sentence and this feels too long. It said this is the right sentence, and it did vary downward to get to that sentence, which suggests an awareness of discretion under Dean. And that also followed a thoughtful consideration of the sentencing factors. It's also important here, Smith acknowledged in district court briefing that the court did know its discretion under Dean, and the court was reminded of its discretion under Dean by Mr. Smith at the sentencing. So I really think all the evidence here shows that this is an experienced district court judge who conducted a careful sentencing. Many arguments were raised at sentencing, and the court addressed every argument that needed to be addressed and gave a fulsome explanation of its below guideline sentence. And Mr. Smith's primary argument that the sentence was substantively unreasonable is based on the idea that the court made these procedural errors. So it's the government's position that no procedural errors were made, and the below guideline sentence was substantively reasonable. And there's nearly a rebuttable presumption that that's the case. If the court has no further questions, the government will ask that the court affirm and rest on the arguments in its brief.
Thank you.
Thank you, Your Honors.
Thank you, Mr. Rosen. Please give him his full 2 minutes.
Thank you, Your Honor. Thank you, Judge Rovner. I think there was a good deal of, clearly judgment did consider a number of the factors that were raised by defense counsel, but he did not consider my client's family support. Criminal history is no aggressive behavior against individuals. His history of being a small-time drug dealer for basically just to survive. I think that I can't remember what my counsel put in the memorandum, but I did review the sentencing transcript, and there was no mention about his cooperation. But that's still something that.
But did you raise that?
I didn't do the trial. No.
Did whomever was representing him at sentencing?
Not at the sentencing hearing.
Okay.
I did not, but I don't recall.
So then how could the court have addressed that as a mitigating factor if it wasn't raised as one that's...
I can't remember what was in the memorandum.
I didn't see anything.
Well, then I will concede that there wasn't, but the court could have, but I see where the court's coming from, that it's... And I don't know about this being the ability to obtain. I understand where the court's coming from with this good credit. All I do remember was in the transcript was the government never got up and said, that's not true. He can take those classes. Nothing like that was ever said by the government at that point in time. So court is aware. That's all I can recite is that.
Is it your position that he can't take classes at all because of the 924C conviction?
I'm relying upon what was at the hearing, which is what counsel said, which was, once again, unrebutted. The government had the opportunity to get up there and say, that's not true, he can do it, and they never did that. Nobody ever did that, and Judge Mim never considered that. And so that's where we're going. Although he knew of his discretion under Dean, I don't believe he followed it. I think that he basically gave him credit under 3553 based upon the guidelines for the predicate offense. Gave him the 60 months, but just piggyback that on to the additional 60 months. So I think he did abuse his discretion. Thank you, Your Honor.
All right, wait, I have to thank you again. We have to doubly thank you,
Thank you, Judge.
both of you, for making, the trip and for sticking with it and for, giving your time and for taking the appointment. Thank you so very much, Mr. Rosen. This wasn't an easy day to come to court on. And that goes for you too, Ms. Boyle. And again, thank you, Ms. Boyle, for the forthright way you respond to questions. And I'm sure you won't be punished for doing it. Okay. Thank you so much to both of you. Case taken under advisement. Have a good trip back. And court is adjourned until tomorrow morning at 9:30. Thank you, everyone.